Introduction. Section I. On the study of the law, the science of the laws and constitution of our own country is a species of knowledge, in which the gentlemen of England have been more remarkably deficient than those of all Europe besides. In most of the nations on the continent, where the civil or imperial law, under different modifications, is closely interwoven with the municipal laws of the land, no gentleman, or at least no scholar, thinks his education is completed till he has attended a course or two of lectures, both on the institutes of Justinian and the local constitutions of his native soil, under the very eminent professors that abound in their several universities. And in the northern part of our own island, where also the municipal laws are frequently connected with the civil, it is difficult to meet with a person of liberal education, who is destitute of a competent knowledge in that science, which is to be the guardian of his natural rights, and the rule of his civil conduct. Nor have the imperial laws been totally neglected even in the English nation. A general acquaintance with their decisions has ever been deservedly considered as no small accomplishment of a gentleman, and a fashion formerly prevailed to transport the growing hopes of this island to foreign universities in Switzerland, Germany, and Holland, which, though infinitely inferior to our own in every other consideration, have been looked upon as better nurseries of the civil, or, which is nearly the same, of their own municipal law. In the meantime it has been the peculiar lot of our admirable system of laws to be vol. I.B. 2 on the study of the law. Neglected, and even unknown, by all but one practical profession, though built upon the soundest foundations and approved by the experience of ages. Far be it from me to derogate from the study of the civil law, considered, apart from any binding authority, as a collection of written reason. No man is more thoroughly persuaded of the general excellence of its rules and the usual equity of its decisions, nor is better convinced of its use as well as ornament to the scholar, the divine, the statesman, and even the common lawyer. But we must not carry our veneration so far as to sacrifice our Alfred and Edward to the manes of Theodosius and Justinian. We must not prefer the edict of the praetor, or the rescript of the Roman emperor, to our own immemorial customs, or the sanctions of an English parliament, unless we can also prefer the despotic monarchy of Rome and Byzantium, for whose meridians the former were calculated, to the free constitution of Britain, which the latter are adapted to perpetuate. Without detracting, therefore, from the real merit which abounds in the imperial law, I hope I may have leave to assert, that if an Englishman must be ignorant of either the one or the other, he had better be a stranger to the Roman than the English institutions. For I think it an undeniable position, that a competent knowledge of the laws of that society in which we live is the proper accomplishment of every gentleman and scholar, a highly useful, I had almost said essential, part of a liberal and polite education. And in this I am warranted by the example of ancient Rome, where, as Cicero informs us, the very boys were obliged to learn the 12 tables by heart, as a carmen necessarium, or indispensable lesson, to imprint on their tender minds an early knowledge of the laws and constitution of their country. But as the long and universal neglect of this study with us in England seems in some degree to call in question the truth of this evident position, it shall therefore be the business of this introductory discourse to demonstrate the utility of some general acquaintance with the municipal law of the land, by pointing out its particular uses in all considerable situations of life. And first, to demonstrate the utility of some acquaintance with on the study of the law, 3 the laws of the land, let us only reflect a moment on the singular frame and polity of that land, which is governed by this system of laws. A land, perhaps the only one in the universe, in which political or civil liberty is the very end and scope of the Constitution. This liberty, rightly understood, consists in the power of doing whatever the laws permit, which is only to be effected by a general conformity of all orders and degrees to those equable rules of action, by which the meanest individual is protected from the insults and oppression of the greatest. As therefore every subject is interested in the preservation of the laws, it is incumbent upon every man to be acquainted with those, at least, with which he is immediately concerned, lest he incur the censure, as well as inconvenience, of living in society without knowing the obligations which it lays him under. And thus much may suffice for persons of inferior condition, who have neither time nor capacity to enlarge their views beyond that contracted sphere in which they are appointed to move. But those on whom nature and fortune have bestowed more abilities and greater leisure cannot be so easily excused. These advantages are given them, not for the benefit of themselves only, but also of the public, and yet they cannot, in any scene of life, discharge properly their duty either to the public or themselves without some degree of knowledge in the laws. To evince this the more clearly, it may not be amiss to descend to a few particulars. Let us, therefore, begin with our gentlemen of independent estates and fortune, the most useful, as well as considerable, body of men in the nation, whom even to suppose ignorant in this branch of learning is treated by Locke ** as a strange absurdity. It is their landed property, with its long and voluminous train of descents and conveyances, settlements, entails, and encumbrances, that forms the most intricate and most extensive object of legal knowledge. The thorough comprehension of these, in all their minute distinctions, is, perhaps, too laborious a task for any but a lawyer by profession, yet still the understanding of a few leading principles relating to estates and conveyancing may form some check and guard upon a gentleman's inferior agents and preserve him at least from very gross and notorious impositions. Montesque, Esp. L. 1. 11 c. 5. Facu adiu, quod aic facer libet, nisi quid Roman 6, aut dur prohi heter. Ins. 1. 3. 1. Educatio section of the law. Again, the policy of all laws has made some forms necessary in the wording of last wills and testaments, and certain requisites with regard to their attestation. And ignorance in these must always be of dangerous consequence to such as, by choice or necessity, compile their own testaments without any technical assistance. Those who have attended the courts of justice are the best witnesses of the confusion and distress that are hereby occasioned in families, and of the difficulties that arise in discerning the true meaning of a testator, or sometimes in discovering any meaning at all, so that in the end his estate may often be vested quite contrary to these his enigmatical intentions, because, perhaps, he has omitted one or two formal words, which are necessary to ascertain the sense with indisputable legal precision, or has executed his will in the presence of fewer witnesses than the law requires. But to proceed from private concerns to those of a more public consideration. All gentlemen of fortune are, in consequence of their property, liable to be called upon to establish the rights, to estimate the injuries, to weigh the accusations, and sometimes to dispose of the lives of their fellow subjects, by serving upon juries. In this situation they have frequently a right to decide, and that upon their oaths, questions of nice importance, in the solution of which some legal skill is requisite, especially where the law and the fact, as it often happens, are intimately blended together. And the general incapacity, even of our best juries to do this with any tolerable propriety, has greatly debased their authority, and has unavoidably thrown more power into the hands of the judges to direct, control, and even reverse their verdicts, than perhaps the Constitution intended. But it is not as a juror only that the English gentleman is called upon to determine questions of right and distribute justice to his fellow subjects. It is principally with this order of men that the commission of the peace is filled. And here a very ample field is open for a gentleman to exert his talents by maintaining good order in his neighborhood, by punishing the dissolute and idle, by protecting the peaceable and industrious, and, above all, by healing petty differences and preventing vexatious prosecutions. But in order to attain these desirable ends, it is necessary that the magistrate should understand his business, and have not only the will, but the power also, under which must be included the knowledge of administering legal. On the study of the law. 5. And effectual justice. Else, when he has mistaken his authority, through passion, through ignorance, or absurdity, he will be the object of contempt from his inferiors and of censure from those to whom he is accountable for his conduct. Yet farther. Most gentlemen of considerable property, at some period or other in their lives, are ambitious of representing their country in Parliament, and those who are ambitious of receiving so high a trust would also do well to remember its nature and importance. They are not thus honorably distinguished from the rest of their fellow subjects, merely that they may enjoy a few peculiar privileges. That they may list under party banners, may grant or withhold supplies, may vote with or vote against a popular or unpopular administration, but upon considerations far more interesting and important. They are the guardians of the English Constitution, the makers, repealers, and interpreters of the English laws, delegated to watch, to check, and to avert every dangerous innovation, to propose, to adopt, and to cherish any solid and well-weighed improvement, bound by every tie of nature, of honor, and of religion, to transmit that Constitution and those laws to their posterity, amended if possible, at least without any derogation. And how unbecoming must it appear in a member of the legislature to vote for a new law when he is utterly ignorant of the old? What kind of interpretation can he be enabled to give, who is a stranger to the text upon which he comments? Indeed, it is perfectly amazing that there should be no other state of life, no other occupation, art, or science, in which some method of instruction is not looked upon as requisite, except only the science of legislation, the noblest and most difficult of any. Apprenticeships are held necessary to almost every art, commercial or mechanical. A long course of reading and study must form the divine, the physician, and the practical professor of the laws. But every man of superior fortune thinks himself born a legislator. Yet Cicero was of a different opinion. It is necessary for a senator to be thoroughly acquainted with the Constitution, and this is a knowledge of the most extensive nature, a matter of science, of diligence, of reflection, without which no senator can possibly be fit for his office. The mischiefs that have arisen to the public from inconsiderate of the law. Alterations in our laws are too obvious to be called in question. And how far they have been, owing to the defective education of our senators, is a point well worthy of public attention. The common law of England has fared like other venerable edifices of antiquity, which rash and inexperienced workmen have ventured to new dress and refine, with all the rage of modern improvement. Hence frequently its symmetry has been destroyed, its proportions distorted, and its majestic simplicity changed for specious embellishments and fantastic novelties. For, to say the truth, almost all the perplexed questions, almost all the niceties, intricacies, and delays which have sometimes disgraced the English as well as other courts of justice, owe their origin not to the common law itself, but to innovations that have been made in it by acts of Parliament, overladen with provisos and additions, and many times on a sudden penned or corrected by men of none or very little judgment in law. Sir Edward Coke declares that in all his time he never knew two questions made upon rights merely depending upon the common law, and warmly laments the confusion introduced by ill-judging and unlearned legislators. But if acts of Parliament were after the old fashion penned by such only as perfectly knew what the common law was before the making of any act of Parliament concerning that matter, as also how after former statutes had provided remedy for former mischiefs and defects discovered by experience, then should very few questions in law arise, and the learned should not so often and so much perplex their heads to make atonement and peace by construction of law between insensible and disagreeing words, sentences, and provisos, as they now do. What is said of our gentlemen in general, and the propriety of their application to the study of the laws of their country, will hold equally strong, or still stronger, with regard to the nobility of this realm, except only in the article of serving upon juries. But, instead of this, they have several peculiar provinces of far greater consequence and concern, being by birth hereditary councillors of the crown, and judges upon their honour of the to so much larger bulk, unless it if, add Sir William Blackstone, should both found, which is assuredly this inconvenience was so heavily felt and not the case, that the pangs of the reign of Queen Elizabeth, how much modem statutes have proportionably must the evil have increased and later better informed themselves in the no times, when the statute book is swelled ledge of the common law. Of the law. 7 lives of their brother peers. Ignorance of the laws of the land should ever be esteemed dishonorable in those who are entrusted by their country to maintain, to administer, and to mend them. Nor will some degree of legal knowledge be found in the least superfluous to persons of inferior rank, especially those of the learned professions. The clergy, in particular, besides the common obligations they are under in proportion to their rank and fortune, have also abundant reason, considered merely as clergymen, to be acquainted with many branches of the law, which are almost peculiar and appropriated to themselves alone. Such are the laws relating to advocens, institutions, and inductions, to simony and simoniacal contracts, to uniformity, residence, and pluralities, to tithes and other ecclesiastical dues, to marriages, and to a variety of other subjects which are consigned to the care of their order by the provisions of particular statutes. To understand these aright, to discern what is warranted or enjoined, and what is forbidden by law, demands a sort of legal apprehension, which is no otherwise to be acquired than by use and a familiar acquaintance with legal writers. For the gentlemen of the faculty of physic, I must frankly own that I see no special reason why they in particular should apply themselves to the study of the law, unless in common with other gentlemen, and to conjure the character of general and extensive knowledge, a character which their profession, beyond others, has remarkably deserved. They will give me leave, however, to suggest, and that not ludicrously, that it might frequently be of use to families, upon sudden emergencies, if the physician were acquainted with the doctrine of last wills and testaments, at least so far as relates to the formal part of their execution. But those gentlemen who intend to profess the civil and ecclesiastical laws in the spiritual and maritime courts of this kingdom are of all men, next to common lawyers, the most indispensably obliged to apply themselves seriously to the study of our municipal laws. For the civil and canon laws considered with respect, Sir William Blackstone here adds, the Lord Chancellor and such other peers, and arbiters of the property of all there as have held high judicial office, fellow subjects, and that in the last re on this subject, O'Connor's case, 11 sci. Sort and C. But for many years the and fin. 155, and the peers. Debate on appellate jurisdiction of the House of their appellate jurisdiction, 2 Macqueen's Lordsley has been exercised exclusively by Rep. 577. The study of the law, to any intrinsic obligation, have no force or authority in this kingdom. They are no more binding in England than our laws are binding at Rome. But as far as these foreign laws, on account of some peculiar propriety, have in some particular cases and in some particular courts been introduced and allowed by our laws, so far they oblige, and no farther, their authority being wholly founded upon that permission and adoption, in which we are not singular in our notions, for, even in Holland, where the imperial law is much cultivated, and its decisions pretty generally followed, we are informed by Van Leeuwen, that it receives its force from custom, and the consent of the people, either tacitly or expressly given, for otherwise, he adds, we should no more be bound by this law than by that of the Almains, the Franks, the Saxons, the Goths, the Vandals, and other of the ancient nations. Wherefore, in all points in which the different systems depart from each other, the law of the land takes place of the law of Rome, whether ancient or modern, imperial or pontifical. And, in those of our English courts, wherein a reception has been allowed to the civil and canon laws, if either they exceed the bounds of that reception, by extending themselves to other matters than are permitted to them, or if such courts proceed according to the decisions of those laws, in cases wherein it is controlled by the law of the land, the common law in either instance, both may, and frequently does, prohibit and annul their proceedings, and it will not be a sufficient excuse for them to tell the courts at Westminster that their practice is warranted by the laws of Justinian or Gregory, or is conformable to the decrees of the Rota, or imperial chamber. For which reason it becomes highly necessary for every civilian and canonist, who would act with safety as a judge, or with prudence and reputation as an advocate, to know in what cases and how far the English laws have given sanction to the Roman, in what points the latter are rejected, and where they are both so intermixed and blended together as to form certain supplemental parts of the common law of England, distinguished by the titles of the maritime, the military, and the ecclesiastical law. Such being the general use and necessity of some acquaint. Dedicatio corporis juris civilis. The study of the law. 9 ants with the common law. I shall now proceed to inquire why the study of it has fallen into disuse. Sir John Fortescue, in his panegyric on the laws of England, which was written in the reign of Henry VI, puts a very obvious question in the mouth of the young prince, whom he is exhorting to apply himself to that branch of learning. Why? The laws of England being so good, so fruitful, and so commodious are not taught in the universities as the civil and canon laws are? In answer to which he gives what seems, with due deference be it spoken, a very genuine and unsatisfactory reason, being, in short, that, as the proceedings at common law were in his time carried on in 3 different tongues, the English, the Latin, and the French, that science must be necessarily taught in those 3 several languages, but that in the universities all sciences were taught in the Latin tongue only. And therefore he concludes that they could not be conveniently taught or studied in our universities. But, without attempting to examine seriously the validity of this reason, the very shadow of which asterisk has long been entirely taken away, we perhaps may find out a better, or at least a more plausible account, why the study of the municipal laws has been so long neglected in these seats of science, than what the learned Chancellor thought it prudent to give to his royal pupil. That ancient collection of unwritten maxims and customs which is called the common law, however compounded, or from whatever fountains derived, had subsisted immemorially in this kingdom, and, though somewhat altered and impaired by the violence of the times, had in great measure weathered the rude shock of the Norman conquest. This had endeared it to the people in general, as well because its decisions were universally known, as because it was found to be excellently adapted to the genius of the English nation. In the knowledge of this law consisted great part of the learning of those dark ages. It was then taught, says Selden *, in the monasteries, in the universities, and in the families of the principal nobility. The clergy in particular, as they then engrossed almost every other branch of learning, so, like their predecessors the British Druids, they were peculiarly remarkable for their proficiency in the study of the law. Envi mus clericus nisi causidicus is the character given of in Flood 27. The law. Them soon after the conquest by William of Malmesbury. The judges therefore were usually created out of the sacred order / as was likewise the case among the Normans, and all the inferior offices were supplied by the lower clergy, which has occasioned their successors to be denominated clerks to this day. But the common law of England, being not committed to writing, but only handed down by tradition, use, and experience, was not so heartily relished by the foreign clergy, who came over hither in shoals during the reign of the Conqueror and his 2 sons, and were utter strangers to our constitution as well as our language. It was about this time that the study of the civil law, after an extinction of 6 centuries, was revived over the whole continent of Europe, and it soon became in a particular manner the favorite of the clergy, who borrowed therefrom the method and many of the maxims of the canon law. The study of it was introduced into several universities abroad, particularly that of Bologna, where exercises were performed, lectures read, and degrees conferred in this faculty, as in other branches of science, and many nations on the continent, just then beginning to recover from the convulsions consequent upon the overthrow of the Ottoman Empire, and settling by degrees into peaceable forms of government, adopted the civil law as the basis of their several constitutions, blending and interweaving it among their own feudal customs, in some places with a more extensive, in others a more confined authority. Nor was it long before the prevailing mode of the times reached England. For Theobald, a Norman abbot, being elected to the see of Canterbury, A.D. 1138, and extremely addicted to this new study, brought over with him in his retinue many learned proficients therein, and among the rest Vicarius, whom he placed in the University of Oxford, to teach it to the people of this country. But it did not meet with the same easy reception in England, where a mild and rational system of laws had been long. Digest. K. 1. 4. Demat's Treatise of Laws, c. 13, section 9. Dugdale, Orig. Jurid, c. 8. Epistole, Innocent Roman 4. In M. Paris, A.D. Les Juges sans sages persons et 1254. Authentiques siccum les archives degrees Gervas. Dorubum. Ac. Pontiff. Keinvesquex les chanoins des églises cathatoires. Call 1665. See an account of the droits et les autres persons qui ont teaching and works of vicarious in doctor, dignitas in sancts églises, les abbes, les erdings and trod. To the study of the prieurs conventoques, et les gouverneurs des civil law. Laudon, 1837. Églises N.C. Grand Caustemir ch. 9. Study of the law. 11 established as it did upon the continent, and though the monkish clergy, devoted to the will of a foreign primate, received it with eagerness and zeal, yet the laity, who were more interested to preserve the old constitution, and had already severely felt the effect of many Norman innovations, continued wedded to the use of the common law. King Stephen also published a proclamation forbidding the study of the laws, then newly imported from Italy, which was treated by the monks as a piece of impiety, and though it might prevent the introduction of the civil law process into our courts of justice, yet did not hinder the clergy from reading and teaching it in their ovum schools and monasteries. From this time the nation seems to have been divided into two parties, the bishops and clergy, many of them foreigners, who applied themselves wholly to the study of the civil and canon laws, which now came to be inseparably interwoven with each other, and the nobility and laity, who adhered with equal pertinacity to the old common law, each of them reciprocally jealous of what they were unacquainted with, and neither of them perhaps allowing the opposite system that real merit which is abundantly to be found in each. This appears, on the one hand, from the spleen with which the monastic writers speak of our municipal laws upon all occasions, and on the other, from the firm temper which the nobility showed at the famous Parliament of Merton, when the prelates endeavored to procure an act to declare all bastards legitimate, in case the parents intermarried at any time afterwards, alleging this only reason, that Holy Church declared such children legitimate. But all the earls and barons with one voice answered that they would not change the laws of England which had hitherto been used and approved. And we find the same jealousy prevailing above a century afterwards, when the nobility declared with a kind of prophetic spirit that the realm of England hath never been unto this hour, neither by the consent of our Lord the King and the Lords of Parliament, shall it ever be ruled or governed by the civil law. And of this temper between the clergy and laity many more instances might be given. Rog. Bacon cuat. Persilden tn Polydor. Verg. Hist. 1. 9. Fledem 7, 6, in Fortis. C. 33, and 8 sta. Merton. 20 hen. Roman 3. C. 9. Rep. Bref. 11 rich. Roman 2. Joan. Sarisbarians. Holocrat. 822. Selden. Jan. Angler. 1. 2. Section 43. Tien. Joan. Saribodio H. Holocrat. Dub 5. 16. Fordesk. C. 33. The study of the law. While things were in this situation, the clergy, finding it impossible to root out the municipal law, began to withdraw themselves by degrees from the temporal courts, and to that end, very early in the reign of King Henry III, episcopal constitutions were published forbidding all ecclesiastics to appear as advocates in foros seculari, nor did they long continue to act as judges there, not caring to take the oath of office which was then found necessary to be administered, that they should in all things determine according to the law and custom of this realm, though they still kept possession of the high office of chancellor, an office then of little juridical power, and afterwards, as its business increased by degrees, they modeled the process of the court at their own discretion. But wherever they retired, and wherever their authority extended, they carried with them the same zeal to introduce the rules of the civil, in exclusion of the municipal law. This appears in a particular manner from the spiritual courts of all denominations, from the Chancellor's courts in both our universities, and from the High Court of Chancery before mentioned, in all of which the proceedings have hitherto been in a course much conformed to the civil law, for which no tolerable reason can be assigned, unless that these courts were all under the immediate direction of ecclesiastics, among whom it was a point of religion to exclude the municipal law, Pope Innocent IV having forbidden the very reading of it by the clergy, because its decisions were not founded on the imperial constitutions, but merely on the customs of the laity. And if it be considered that our universities began about that period to receive their present form of scholastic discipline, that they were then, and continued to be till the time of the Reformation, entirely under the influence of the clergy, this will lead us to perceive the reason why the study of the common laws was pursued with such alacrity in these seats of learning, and why the common law was entirely despised, and esteemed little better than heretical. And, since the Reformation, many causes have conspired to prevent its becoming a part of academical education. As, first, long usage and established custom, which, as in everything else, so Spellman, Consul. A.D. 1217. Wilkins. Selden and Fledham, 9, 3. Condi Vol. 1. p. 574, 599. M. Harris, A.D. 1254. Op the law. 13 especially in the forms of scholastic exercise have justly great weight and authority. Secondly, the real intrinsic merit of the civil law, considered upon the footing of reason and not of obligation, and the ignorance of the merit of the common law, though its equal at least, and perhaps an improvement on the other. But the principal reason of all that has hindered the introduction of this branch of learning is, that the study of the common law, being banished from the universities, fell into quite a different channel, and has till quite recently been wholly cultivated in another place. For, being entirely abandoned by the clergy, a few stragglers excepted, the study and practice of it devolved of course into the hands of laymen, who entertained upon their parts a most hearty aversion to the civil law, and made no scruple to profess their contempt, nay, even their ignorance of it, in the most public manner. But still, as the balance of learning was greatly on the side of the clergy, and as the common law was no longer taught as formerly in any part of the kingdom, it must have been subjected to many inconveniences, and perhaps would have been gradually lost and overrun by the civil, a suspicion well justified from the frequent transcripts of Justinian to be met with in Bracton and Fleda, had it not been for a peculiar incident, which happened at a very critical time, and contributed greatly to its support. The incident which I mean was the fixing the Court of Common Pleas, the grand tribunal for disputes of property, to be held in one certain spot, that the seat of ordinary justice might be permanent and notorious to all the nation. Formerly that, in conjunction with all the other superior courts, was held before the King's Capital Justiciary of England, in the Aula Regis, or such of his palaces wherein his royal person resided, and removed with his household from one end of the kingdom to the other. This was found to occasion great inconvenience to the suitors, to remedy which it was made an article of the Great Charter of Liberties, both that of King John and King Henry III, that common pleas should no longer follow the King's court, but be held in some certain place. In consequence of which they have ever since been held, a few necessary removals in times of the Fortesque de Laud, LL. N. C. 23. The study of the law, plague excepted, in the Palace of Westminster only. This brought together the professors of the municipal law, who before were dispersed about the kingdom, and formed them into an aggregate body, whereby a society was established of persons, who, addicting themselves wholly to the study of the laws of the land, and no longer considering it as a mere subordinate science, for the amusement of leisure hours, soon raised those laws to that pitch of perfection, which they suddenly attained under the auspices of our English Justinian, King Edward I. In consequence of this lucky assemblage, they naturally fell into a kind of collegiate order, and, being excluded from Oxford and Cambridge, found it necessary to establish a new university of their own. This they did by purchasing at various times certain houses, now called the Inns of Court and of Chancery, between the city of Westminster, the place of holding the King's courts, and the City of London, for advantage of ready access to the one, and plenty of provisions in the other. Here exercises were performed, lectures read, and degrees were at length conferred in the common law, as at other universities in the canon and civil. The degrees were those of barristers, who answered to bachelors, as the state and degree of a serjeant, *serventes ad legem, did to that of doctor. The Crown seems to have soon taken under its protection this infant seminary of common law, and the more effectually to foster and cherish it. King Henry III, in the 19th year of his reign, issued out an order directed to the mayor and sheriffs of London, commanding that no regent of any law schools within that city should for the future teach law therein. Registered the word law, or leges, being a general term, may create some doubt at this distance of time, whether the teaching of the civil law, or the common, or both, is hereby restrained. But in either case it tends to the same end. If the civil law only is prohibited, which is Selden's opinion, it is then a retaliation upon the clergy, who had excluded the common law from their seats. Spelman, Gloss 33. Orig. Jurid 55. Fortis c. 48. Manning's Servians ad legem. Lon Herbert's account of the Inns of Dawn, 1840. Court and Chancery, London, 104. Ni aliquis scholas regions de legis equals first styled apprentices from ap in idem civitate de sixtiro ibitum leges prender, and who seem to have been first docet. Appointed by an ordinance of Edward. In Fle. 8-2. The first. Spell. Gloss. 37. Dugdale. On the study of the law. 15 of learning. The municipal law be also included in the restriction, as Sir Edward Coke understands it, and which the words seem to import, then the intention is evidently this. By preventing private teachers within the walls of the city, to collect all the common lawyers into the one public university, which was newly instituted in the suburbs. In this juridical university, for such it is insisted to have been by Fortescue and Sir Edward Coke, there were two sorts of collegiate houses, one called Inns of Chancery, in which the younger students of the law were usually placed. Learning and studying, says Fortescue, the originals and as it were the elements of the law, who, profiting therein as they grew to ripeness, so were they admitted into the greater inns of the same study, called the Inns of Court. And in these inns of both kinds, he goes on to tell us, the knights and barons, with other grandees and noblemen of the realm, did use to place their children, though they did not desire to have them thoroughly learned in the law, or to get their living by its practice, and that in his time there were about 2,000 students at the several inns, all of whom, he informs us, were filii nobiliumi or gentlemen born. Hence it is evident that, though under the influence of the monks our universities neglected the study, yet, in the time of Henry VI, it was thought highly necessary, and was the universal practice, for the young nobility and gentry to be instructed in the origin and elements of the laws. But by degrees this custom fell into disuse, so that, in the reign of Queen Elizabeth, Sir Edward Coke did not reckon above 1,000 students, and the number 2 centuries later was very considerably less. This was then attributed principally to these reasons. First, because the Inns of Chancery being then almost totally filled by the inferior branch of the profession, were neither commodious nor proper for the resort of gentlemen of any rank or figure, so that there were very rarely any young students entered at the Inns of Chancery. Secondly, because in the Inns of Court all sorts of regimen and academical super tu inst proem. I3 rep. Pref. De Laud. LL. N. C. 49. BL Com. Vo Li. P. 25. Free rep. Pref. Of the law. Intendants, either with regard to morals or studies, were found impracticable, and therefore entirely neglected. Lastly, because persons of birth and fortune, after having finished their usual courses at the universities, had seldom leisure or resolution sufficient to enter upon a new scheme of study at a new place of instruction. Few gentlemen now resort to the Inns of Court, but such as are intended for the profession. The rest of our gentry, not to say our nobility also, have usually retired to their estates, or visited foreign kingdoms, or entered upon public life, without any instruction in the laws of the land, and indeed with hardly any opportunity of gaining instruction, unless it has been afforded them. At the universities. That the universities are the proper places for affording assistance of this kind to gentlemen of all stations and degrees cannot with any color of reason be denied. And the advantages that might result to the science of the law itself, when a little more attended to in these seats of knowledge, would perhaps be very considerable. The leisure and abilities of the learned in these retirements might either suggest expedients or execute those dictated by wiser heads, for improving its method, retrenching its superfluities, and reconciling the little contrarieties which the practice of many centuries will necessarily create in any human system, a task which those who are deeply employed in business and the more active scenes of the profession can hardly condescend to engage in. And as to the interest, or, which is the same, the reputation of the universities themselves, if ever this study should arrive to any tolerable perfection there, the nobility and gentry of this kingdom will not shorten their residence upon this account, nor perhaps entertain a worse opinion of the benefits of academical education. For it is past dispute that those gentlemen, who resort to the Inns of Court with a view to pursue the profession, will find it expedient, whenever it is practicable, to lay the previous foundations of this, as well as every other science, in one of our learned universities. We may appeal to the experience of every sensible lawyer, whether anything can be more hazardous or discouraging than the usual entrance on the study of the law. A raw and inexperienced youth, in the most dangerous season of life, is transplanted on a sudden into the midst of allurements to pleasure, without any restraint or check but what his own prudence can. Study of the law. 17 suggest. In this situation he is expected to sequester himself from the world, and by a tedious study to extract the theory of law from a mass of undigested learning, or else by an assiduous attendance on the courts to pick up theory and practice together, sufficient to qualify him for the ordinary run of business. How little, therefore, is it to be wondered at that we hear of so frequent miscarriages, that so many gentlemen of bright imaginations grow weary of so unpromising a pursuit, and addict themselves wholly to amusements or other less innocent occupations, and that many persons of moderate capacity confuse themselves at first setting out, and continue ever dark and puzzled during the remainder of their lives. The evident want of some assistance in the rudiments of legal knowledge has given birth to a practice which, if ever it had grown to be general, must have proved of extremely pernicious consequence. I mean the custom by some so very warmly recommended of dropping all liberal education, as of no use to students in the law, and placing them, in its stead, at the desk of some skillful attorney, in order to initiate them early in all the depths of practice and render them more dexterous in the mechanical part of business. A few instances of particular persons, men of excellent learning and unblemished integrity, who, in spite of this method of education, have shone in the foremost ranks of the bar, have afforded some kind of sanction to Telia's illiberal path to the profession, and biased many parents of short-sighted judgment in its favor. Not considering that there are some geniuses, formed to overcome all disadvantages, and that from such particular instances no general rules can be formed, nor observing that those very persons have frequently recommended, by the most forcible of all examples, the disposal of Telia's own offspring, a very different foundation of legal studies, a regular academical education. Making therefore due allowance for one or two shining exceptions, experience may teach us to foretell that a lawyer thus educated to the bar, in subservience to attorneys and solicitors, will find he has begun at the wrong end. If practice be the whole he is taught, practice must also be the whole he will ever know. If he be misinstructed in the elements and first principles upon which the rule of practice is founded, the least variation from established precedents will totally distract and bewilder him. Ita lex scripta est is the utmost his knowledge will arrive at. He vol. I. The study of the law must never aspire to form, and seldom expect to comprehend, any arguments drawn a priori from the spirit of the laws and th6 natural foundations of justice. Nor is this all, for as few persons of birth or fortune, or even of scholastic education, will submit to the drudgery of servitude, and the manual labor of copying the trash of an office. Should this infatuation prevail to any considerable degree, we must rarely expect to see a gentleman of distinction or learning at the bar. And what the consequence may be, to have the interpretation and enforcement of the laws which include the entire disposal of our properties, liberties, and lives fall wholly into the hands of obscure or illiterate men, is matter of very public concern. The inconveniences here pointed out can never be effectually prevented, but by making academical education a previous step to the profession of the common law, and at the same time making the rudiments of the law part of academical education. For sciences are of a sociable disposition, and flourish best in the neighborhood of each other, nor is there any branch of learning but may be helped and improved by assistances drawn from other arts. If, therefore, the student in our laws has formed both his sentiment and style, by perusal and imitation of the purest classical writers, among whom lie historians and orators will best deserve his regard, if he can reason with precision, and separate argument from fallacy, by the clear simple rules of pure unsophisticated logic, if he can fix his attention, and steadily pursue truth through any the most intricate deduction, by the use of mathematical demonstrations, if he has enlarged his conceptions of nature and art, by a view of the several branches of genuine experimental philosophy, if he has impressed on his mind the sound maxims of the law of nature, the best and most authentic foundation of human laws, if, lastly, he has contemplated those maxims reduced to a practical system in the laws of imperial calm, if he has done this or any part of it, though all may be easily done, Euler as able instructors as ever graced any seats of learning, a student thus qualified may enter upon the study of the law with incredible advantage and reputation. And if, at the conclusion, or during the acquisition of these accomplishments, he ill afford himself here a year or two's farther leisure to lay the foundation of his future labors in a solid scientific method, without thirsting too early to attain that. The study of the law. 19. Practice which it was impossible he should rightly comprehend, he will afterwards proceed with the greatest ease, and will unfold the most intricate points with an intuitive rapidity and clearness. I shall not insist upon such motives as might be drawn from principles of economy, and are applicable to particulars only. I reason upon more general topics, and therefore to the qualities of the head, which I have just enumerated, I cannot but add those of the heart, affectionate loyalty to the sovereign, a zeal for liberty and the constitution, a sense of real honor, and well-grounded principles of religion, as necessary to form a truly valuable English liege, a Hyde, a Hale, or a Talbot. In the following Commentaries on the Laws of England, I have endeavored to accomplish rather what I conceive an expounder of the laws should do than what I have ever known to be done. He should consider his course as a general map of the law, marking out the shape of the country, its connections and boundaries, its greater divisions and principal cities. It is not his business to describe minutely the subordinate limits, or to fix the longitude and latitude of every inconsiderable hamlet. His attention should be engaged, like that of the readers in Fortescue's Hints of Chancery, in tracing out the originals and, as it were, the elements of the law. For if the tender understanding of the student be loaded at the first with a multitude and variety of matter, it will either occasion him to desert his studies, or will carry him heavily through them, with much labor, delay, and despondence. These originals should be traced to their fountains, as well as our distance will permit, to the customs of the Britons and Germans, as recorded by C.F. Isar and Tacitus, to the codes of the northern nations on the continent, and more especially to those of our own Saxon princes, to the rules of the Roman law either left here in the days of Papinian, or imported by Vacarius and his followers. But above all, to that inexhaustible reservoir of legal antiquities and learning, the feudal law, or, as Spellman Trademark has entitled it, the law of nations in our western orb. These primary rules and fundamental principles should be weighed and compared with the precepts of the law of nature, and the practice of other countries, should be explained by reasons, illustrated by examples, and confirmed by undoubted authorities. Their history should be just TMT 1:1:2 0/parliaments. The study of the law. Deduced, their changes and revolutions observed, and it shall be shown how far they are connected with, or have at any time been affected by, the civil transactions of the kingdom. A plan of this nature, if executed with care and ability, cannot fail of administering a most useful and rational entertainment to students of all ranks and professions, and yet it must be confessed that the study of the laws is not merely a matter of amusement, for the learner will be considerably disappointed if he looks for entertainment without the expense of a 10 degrees in attention, however, not greater than is usually bestowed in mastering the rudiments of other sciences, or sometimes in pursuing a favorite recreation or exercise. And this attention is not equally necessary to be exerted by every student upon every occasion. Some branches of the law, as the formal process of civil suits and the subtle distinctions incident to landed property, which are the most difficult to be thoroughly understood, are the least worth the pains of understanding, except to such gentlemen as intend to pursue the profession. To others I may venture to apply, with a slight alteration, the words of Sir John Fortescue, when first his royal pupil determines to engage in this study. It will not be necessary for a gentleman, as such, to examine with a close application the critical niceties of the law. It will fully be sufficient, and he may well enough be denominated a lawyer, if under the instruction of a master he traces up the principles and grounds of the law, even to their original elements. Therefore, in a very short period, and with very little labor, he may be sufficiently informed in the laws of his country if he will but apply his mind in good earnest to receive and apprehend them. For though such knowledge as is necessary for a judge is hardly to be acquired by the lucubr tions of 20 years, yet with a genius of tolerable perspicacity, that knowledge which is fit for a person of birth or condition may be learned in a single year without neglecting his other improvements. Taylor L.M. of Civil Law. Section Roman 2. On the nature of laws in general. Law, in its most general and comprehensive sense, signifies a rule of action, and is applied indiscriminately to all kinds of action, whether animate or inanimate, rational or irrational. Thus we say, the laws of motion, of gravitation, of optics, or mechanics as well as the laws of nature and of nations. And it is that rule of action which is prescribed by some superior, and which the inferior is bound to obey. Thus, when the Supreme Being formed the universe and created matter out of nothing, he impressed certain principles upon that matter, from which it can never depart, and without which it would cease to be. When he put that matter into motion, he established certain laws of motion, to which all movable bodies must conform, and to descend from those greatest operations to those smallest. When a workman forms a clock, or other piece of mechanism, he establishes, at his own pleasure, certain arbitrary laws for its direction, as that the hand shall describe a given space in a given time, to which law, as long as the work conforms, so long it continues in perfection, and answers the end of its formation. If we farther advance, from mere inactive matter to vegetable and animal life, we shall find them still governed by laws, more numerous indeed, but equally fixed and invariable. The whole progress of plants, from the seed to the root, and from thence to the seed again, the method of animal nutrition, digestion, secretion, and all other branches of vital economy, are not left to chance or the will of the creature itself, but are performed in a wondrous involuntary manner and guided by unerring rules laid down by the great Creator. This, then, is the general signification of law, a rule of action dictated by some superior being, and in those creatures. On the nature of laws in general. Have neither the power to think nor to will, such laws must be invariably obeyed, so long as the creature itself subsists, for its existence depends on that obedience. But laws, in their more confined sense, and in which it is our present business to consider them, denote the rules, not of action in general, but of human action or conduct, that is, the precepts by which man, the noblest of all sublunary beings, a creature endowed with both reason and free will, is commanded to make use of those faculties in the general regulation of his behavior. Man, considered as a creature, must necessarily be subject to the laws of his Creator, for he is entirely a dependent being. A being, independent of any other, has no rule to pursue, but such as he prescribes to himself, but a state of dependence will inevitably oblige the inferior to take the will of him, on whom he depends as the rule of his conduct, not indeed in every particular, but in all those points wherein his dependence consists. This principle, therefore, has more or less extent and effect, in proportion as the superiority of the one and the dependence of the other is greater or less absolute or limited. And consequently, as man depends absolutely upon his Maker for everything, it is necessary that he should in all points conform to his Maker's will. This will of his Maker is called the law of nature, for as God, when he created matter, and endued it with a principle of mobility, established certain rules for the perpetual direction of that motion, so, when he created man, and endued him with free will to conduct himself in all parts of life, he laid down certain immutable laws of human nature, whereby that free will is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws. Considering the Creator only as a being of infinite power, he was able unquestionably to have prescribed whatever laws he pleased to his creature, man, however unjust or severe. But as he is also a being of infinite wisdom, he has laid down only such laws as were founded in those relations of justice that existed in the nature of things antecedent to any positive precept. These are the eternal, immutable laws of good and evil, to which the Creator himself in all his dispensations conforms, and which he has enabled human reason to discover, so far as they are necessary for the conduct of human actions. Such among others are these principles: that we should live honestly, should hurt nobody. On the nature of laws in general. 23 odd should render to every one his due, to which 3 general precepts Justinian * has reduced the whole doctrine of law. But if the discovery of these first principles of the law of nature depended only upon the due exertion of right reason, and could not otherwise be obtained than by a chain of metaphysical disquisitions, mankind would have wanted some inducement to have quickened their inquiries, and the greater part of the world would have rested content in mental indolence, and ignorance, its inseparable companion. As, therefore, the Creator is a being, not only of infinite power and emestome, but also of infinite effudness, He has been pleased so to contrive the constitution and frame of humanity, that we should want no other prompter to inquire after and pursue the rule of right, but only our own self-love, that universal principle of action. For he has so intimately connected, so inseparably interwoven the laws of eternal justice with the happiness of each individual, that the latter cannot be attained but by observing the former. And if the former be punctually obeyed, it cannot but induce the latter. In consequence of which mutual connection of justice and human felicity, he has not perplexed the law of nature with a multitude of abstract rules and precepts, referring merely to the fitness or unfitness of things, as some have vainly surmised, but has graciously reduced the rule of obedience to this one paternal precept: that man should pursue his own true and substantial happiness. This is the foundation of what we call ethics or natural law, for the several articles into which it is branched in our systems amount to no more than demonstrating that this or that action tends to man's real happiness, and therefore very justly concluding that the performance of it is a part of the law of nature. Or, on the other hand, that this or that action is destructive of man's real happiness, and therefore that the law of nature forbids it. This law of nature being coeval with mankind, and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe, in all countries, and at all times. No human laws are of any validity, if contrary to this, and such of them as are valid derive all their force and all their authority, mediately or immediately, from this original. Honed vicer, altrum rum ixtir, suum cuique tribura. Lust. I. 1. The nature of laws in general. But in order to apply this to the particular exigencies of each individual, it is still necessary to have recourse to reason, whose office it is to discover, as was before observed, what the law of nature directs in every circumstance of life, by considering what method will tend the most effectually to our own substantial happiness. And if our reason were always clear and perfect, unruffled by passions, unclouded by prejudice, unimpaired by disease or intemperance, the task would be pleasant and easy. We should need no other guide but this: But every man now finds the contrary in his own experience, that his reason is corrupt, and his understanding full of ignorance and error. This has given manifold occasion for the benign interposition of divine providence, which, in compassion to the frailty, the imperfection, and the blindness of human reason, has been pleased at sundry times and in divers manners to discover and enforce its laws by an immediate and direct revelation. The doctrines thus delivered we call the revealed or divine law, and they are to be found only in the Holy Scriptures. These precepts, when revealed, are found upon comparison to be really a part of the original law of nature, as they tend, in all their consequences, to man's felicity. But we are not from thence to conclude that the knowledge of these truths was attainable by reason, in its present corrupted state, since we find that until they were revealed, they were hid from the wisdom of ages. As then the moral precepts of this law are indeed of the same origin with those of the law of nature, so their intrinsic obligation is of equal strength and perpetuity. Yet undoubtedly the revealed law is of infinitely more authenticity than that moral system which is framed by ethical writers and denominated the natural law, because one is the law of nature expressly declared so to be by God himself, the other is only what, by the assistance of human reason, we imagine to be that law. If we could be as certain of the latter as we are of the former, both would have an equal authority. But till then they can never be put in any competition together. Upon these two foundations, the law of nature and the law of revelation, depend all human laws, that is to say, no human laws should be suffered to contradict these. There are, it is true, a great number of indifferent points, in which both the divine, general, 25 and the natural leave a man at his own liberty, but which are found necessary for the benefit of society to be restrained within certain limits. And herein it is that human laws have their greatest force and efficacy, for with regard to such points as are not indifferent, human laws are only declaratory of, and act in subordination to, the former, to instance in the case of murder. This is expressly forbidden by the divine, and demonstrably by the natural law, and from these prohibitions arises the true unlawfulness of this crime. Those human laws that annex a punishment to it, do not at all incretize its moral guilt, or superadd any fresh obligation and foro consentize to abstain from its perpetration. Nay, if any human law should allow or enjoin us to commit it, we are bound to transgress that human law, or else we must offend both the natural and the divine. But with regard to matters that are in themselves indifferent, and are not commanded or forbidden by those superior laws, such, for instance, as exporting of wool into foreign countries, which was at one time prohibited by statute, here the inferior legislature has scope and opportunity to interpose, and to make that action unlawful which before was not so. If man were to live in a state of nature, unconnected with other individuals, there would be no occasion for any other laws than the law of nature and the law of God. Neither could any other law possibly exist. For a law always supposes some superior who is to make it, and in a state of nature we are all equal, without any superior but him who is the author of our being. But man was formed for society, and, as is demonstrated by the writers on this subject, is neither capable of living alone, nor indeed has the courage to do it. However, as it is impossible for the whole race of mankind to be united in one great society, they must necessarily divide into many, and form separate states, commonwealths, and nations entirely independent of each other, and yet liable to a mutual intercourse. Hence arises a third kind of law to regulate this mutual intercourse, called the law of nations, which, as none of these states will acknowledge a superiority in the other, cannot be dictated by any, but depends entirely upon the rules of natural law, or upon mutual compacts, treaties, leagues, and agreements between these several communities. In the construction also of which compacts we have no Ruffdorf 1:701 compared with Borbsidek's Commentary 26 on the nature of laws in general. Other rule to resort to, but the law of nature, being the only one to which all the communities are equally subject, and therefore the civil law very justly observes that quod naturalis ratio inter omnes homines constituit, vocatur just gentium. Thus much I thought necessary to premise concerning the law of nature, the revealed law, and the law of nations, before I proceeded to treat more fully of the principal subject of this section, municipal or civil law. That is, the rule by which particular districts, communities, or nations are governed, being thus defined by Justinian *WS civile ESD quod quisque sibi populus constituit. I call it municipal law, in compliance with common speech, for though, strictly, that expression denotes the particular customs of one single municipium or free town, yet it may with sufficient propriety be applied to any one state or nation, which is governed by the same laws and customs. Municipal law, thus understood, is properly defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. Let us endeavor to explain its several properties as they arise out of this definition. And first, it is a rule, not a transient sudden order from a superior to or concerning a particular person, but something permanent, uniform, and universal. Therefore, a particular act of the legislature to confiscate the goods of Titius, or to attaint him of high treason, does not enter into the idea of a municipal law, for the operation of this act is spent upon Titius only, and has no relation to the community in general. It is rather a sentence than a law, but an act to declare that the crime of which Titius is accused shall be deemed high treason. This has permanency, uniformity, and universality, and therefore is properly a rule. It is also called a rule to distinguish it from advice or counsel, which we are at liberty to follow or not as we see proper and to judge upon the reasonableness or unreasonableness of the thing advised. Whereas our obedience to the law depends not upon our approbation, but upon the Maker's will. Counsel is only matter of persuasion, law is matter of injunction. Counsel acts only upon the willing, law upon the unwilling also. It is also called a rule, to distinguish it from a compact or agreement, for ff. 119 inst. 1, 2. The nature of laws in general. 27. A compact is a promise proceeding /row *us. Law is a command directed to us. The language of a compact is, I will or will not do this. T of a law is, thou shalt or shalt not do it. It is true there is an obligation which a compact carries with it, equal in J-went of conscience to that of a law, but then the origin of the obligation is different. In compacts, we ourselves determine and promise what shall be done, before we are obliged to do it. In hews, we are obliged to act without ourselves determining or promising anything at all. Upon these accounts law is defined to be a rule. Municipal hew is also a rule of civil conduct. This distinguishes municipal law from the natural or revealed, the former of which is the rule of moral conduct, and the latter not only the rule of moral conduct, but also the rule of faith. These regard man as a creature and point out his duty to God, to himself, and to his neighbor, considered in the light of an individual. But municipal or civil law regards him also as a citizen, and bound to other duties towards his neighbor than those of mere nature and religion, duties which he has engaged in by enjoying the benefits of the common union, and which amount to no more than that he do contribute, on his part, to the subsistence and peace of the society. It is like Kenfis, a rule prescribed. Because a bare resolution, confined in the breast of the legislator, without manifesting itself by some external sign, can never be properly a law. It is requisite that this resolution be notified to the people who are to obey it. But the manner in which this notification is to be made is matter of very great difference. It may be notified by universal tradition and long practice, which supposes a previous publication, and is the case of the common law of England. It may be notified, viva voce, by officers appointed for that purpose, as used to be done with regard to proclamations and such acts of Parliament as were appointed to be publicly read in churches and other assemblies. It may lastly be notified by writing, printing, or the like, which is the general course taken with all our Acts of Parliament. Yet, whatever way is made use of, it is incumbent on the promulgators to do it in the most public and perspicuous manner, not like Caligula, who, according to Dio Cassius, wrote his laws in a very small character, and hung them up upon high pillars, the more effectually to ensnare the people. There is still a more unreasonable method than this, which is called making On the nature of laws in general. Laws ex post facto, when after an action, indifferent in itself, is committed, the legislature then for the first time declares it to have been a crime, and inflicts a punishment upon the person who has committed it. Here it is impossible that the party could foresee that an action, innocent when it was done, should be afterwards converted to guilt by a subsequent law. He had therefore no cause to abstain from it, and all punishment for not abstaining must of consequence be cruel and unjust. All laws should be therefore made to commence in futuro, and be notified before their commencement, which is implied in the term prescribed. But when this rule is in the usual manner notified, or prescribed, it is then the subject's business to be thoroughly acquainted therewith. For if ignorance of what he might know were admitted as a legitimate excuse, the laws would be of no effect, but might always be eluded with impunity. But farther, municipal laws. A rule of ill conduct prescribed by the supreme jailer in a state, for legislation, as was before observed, is the greatest act of superiority that can be exercised by one being over another. Wherefore it is requisite to the very essence of law that it be made by the supreme power. Sovereignty and legislature are indeed convertible terms. One cannot subsist without the other. This may lead us into a short inquiry concerning the nature of society and civil government, and the natural, inherent right that belongs to the sovereignty of a state, wherever that sovereignty be lodged, of making and enforcing laws. The only true and natural foundations of society are the wants and the fears of individuals. Not that we can believe, with some theoretical writers, that there ever was a time when there was no such thing as society, either natural or civil, but that, from the impulse of reason, and through a sense of their wants and weaknesses, individuals met together in a large plain, entered into an original contract, and chose the tallest man present to be their governor. This notion, of an actually existing unconnected state of nature, is too wild to be seriously admitted, and besides it is plainly contradictory to the revealed accounts of the primitive. Nova constitutio futuris non pure rexterius specific day is fixed for their comments imponer debit. Moon v. Burden 2x, meant, take effect from the day on W. Leach Rep. 22. They receive the royal lawsuit, 33 Geo. Asterisk. Acts of Parliament in which no Roman 3. C. On the nature of laws in general. 29 Origin of mankind, and their preservation 2,000 years afterwards, both which were effected by the means of single families. These formed the first natural society, among themselves, which, every day extending its limits, laid the first though imperfect rudiments of civil or political society. And when it grew too large to subsist with convenience in that pastoral state wherein the patriarchs appear to have lived, it necessarily subdivided itself by various migrations into more. Afterwards, as agriculture increased, which employs and can maintain a much greater number of hands, migrations became less frequent. And various tribes which had formerly separated, reunited again, sometimes by compulsion and conquest, sometimes by accident, and sometimes perhaps by compact. But though society had not its formal beginning from any convention of individuals actuated by their wants and their fears, yet it is the sense of their weakness and imperfection that keeps mankind together, that demonstrates the necessity of this union, and that, therefore, is the solid and natural foundation as well as the cement of civil society. And this is what we'll mean by the original contract of society, which, though perhaps in no instance it has ever been formally expressed at the first institution of a state, yet in nature and reason must always be understood and implied in the very act of siding together. Namely, that the whole should protect all its arts and that every part should pay obedience to the will of the whole, or, in other words, that the community should guard the rights of each individual member, and that, in return for this protection, each individual should submit to the laws of the community, without which submission of all, it was impossible that protection could be certainly extended to any. For when civil society is once formed, government at the same time results, of course, as necessary to preserve and to keep that society in order, unless some superior be constituted, whose commands and decisions all the members are bound to obey, they would still remain as in a state of nature, without any judge upon earth to define their several rights and redress their several wrongs. But as all the members which compose this society were naturally equal, it may be asked, in whose hands are the reins of government to be entrusted? To this the general answer is easy, but the application of it to particular cases has occasioned one half of those mischiefs which are apt to proceed from misguided political zeal. In general, all mankind. The nature of laws in general will agree that government should be reposed in such persons in whom those qualities are most likely to be found, the perfection of which is among the attributes of him who is emphatically styled the Supreme Being, the three grand requisites, I mean, of wisdom, of goodness, and of power. Wisdom to discern the real interest of the community, goodness to endeavor always to pursue that real interest, and strength, or power, to carry this knowledge and intention into action. These are the natural foundations of sovereignty, and these are the requisites that ought to be found in every well-constituted frame of government. How the several forms of government we now see in the world at first actually began, is matter of great uncertainty, and has occasioned infinite disputes. It is not my business or intention to enter into any of them. However they began, or by what right soever they subsist, there is and must be in all of them a supreme, irresistible, absolute, uncontrolled authority in which the jura summa imiri, or the rights of sovereignty, reside. And this authority is placed in those hands, wherein, according to the opinion of the founders of such respective states, either expressly given, or collected from their tacit approbation, the qualities requisite for supremacy, wisdom, goodness, and power, are the most likely to be found. The political writers of antiquity will not allow more than three regular forms of government. The first, when the sovereign power is lodged in an aggregate assembly, consisting of all the free members of a community, which is called a democracy. The second, when it is lodged in a council, composed of select members, and then it is styled an aristocracy. The last, when it is entrusted in the hands of a single person, and then it takes the name of a monarchy. All other species of government, they say, are either corruptions of or reducible to these three. By the sovereign power, as was before observed, is meant the making of laws, for wherever that power resides, all others must conform to, and be directed by it, whatever appearance the outward form and administration of the government may put on. For it is at any time in the option of the legislature to alter that form and administration by a new edict or rule, and to put the execution of the laws into whatever hands it pleases, by constituting one, or a few, or many executive magistrates. And all the other powers of the state must obey the legislative power in the On the nature of laws in general, 31 discharge of their several functions, or else the Constitution is at an end. In a democracy, where the right of making laws resides in the people at large, public virtue, or goodness of intention, is more likely to be found than either of the other qualities of government. Popular assemblies are frequently foolish in their contrivance, and weak in their execution, but generally mean to do the thing that is right and just, and have always a degree of patriotism or public spirit. In aristocracies there is more wisdom to be found than in the other frames of government, being composed, or intended to be composed, of the most experienced citizens. But there is less honesty than in a republic, and less strength than in a monarchy. A monarchy is, indeed, the emptiest powerful of any, for by the entire conjunction of the legislative and executive powers, all the sinews of government are knit together, united in the hand of the prince. But then there is imminent danger of lies employing that strength to improvident or oppressive purposes. Thus these three species of government have, all of them, their several perfections and imperfections. Democracies are usually the best calculated to direct the end of the law, aristocracies to invent the means by which that end shall be obtained, and monarchies to carry those means into execution. And the ancients, as was observed, had in general no idea of any other permanent form of government but these three, for though Cicero declares himself of opinion, S optime constitutam rim publicam, quo extrahis generibus recall, optimo, et populari sit modus confusa. Yet Tacitus treats this notion of a mixed government, fond out of them all, and partaking of the advantages of each, as a visionary whim, and one that, if effected, could never be lasting or secure. But happily, for us of this island, the British Constitution has long remained a standing exception to the truth of this observation. For, as with us the executive power of the law is lodged in a single person, they have all the advantages of strength and dispatch that are to be found in the most absolute monarchy, and as the legislature of the kingdom is entrusted to three distinct powers, entirely independent of each other. First, the crown; secondly, the lords spiritual and temporal, which is Endahep. L1 c. 29 and c. 45. Tacit. N. 1. 4 c. 32 on the nature of laws in general. Aristocratic assembly of persons elected for their piety, their birth, their wisdom, their valor, or their property, and thirdly, the House of Commons, freely chosen by the people from among themselves, which makes it a kind of democracy. As this aggregate body, actuated by different springs and attentive to different interests, composes the British Parliament, and has the supreme disposal of everything, there can no inconvenience be attempted by either of the three branches, but will be withstood by one of the other two, each branch being armed with a negative power sufficient to repel any innovation which it shall think inexpedient or dangerous. Here then is lodged the sovereignty of the British Constitution, and lodged as beneficially as is possible for society. For in no other shape could we be so certain of finding the three great qualities of government so well and so haptwily united. If the supreme power were lodged in any one of the three branches separately, we must be exposed to the inconveniences of either absolute monarchy, aristocracy, or democracy, and so want two of the three principal ingredients of good polity, either virtue, wisdom, or power. If it were lodged in any two of the branches, for instance in the Crown and House of Lords, our laws might be providently made and well executed, but they might not have always the good of the people in view. If lodged in the Sovereign and Commons, we should want that circumspection and meditatory caution which the wisdom of the peers is to afford. If the supreme rights of legislature were lodged in the two houses only, and the Crown had no negative upon their proceedings, they might be tempted to encroach upon the royal prerogative, or perhaps to abolish the kingly office, and thereby weaken, if not totally destroy, the strength of the executive power. But the constitutional government of this island is so admirably tempered and compounded, that nothing can endanger or hurt it, but destroying the equilibrium of power between one branch of the legislature and the rest. For if ever it should happen that the dependence of any one of the three should be lost, or that it should become subservient to the views of either of the other two, there would soon be an end of our constitution. The legislature would be changed from that which, upon the supposition of an original contract, either actual or implied, is presumed to have been originally set up by the general consent and fundamental act of the society, and such a change, however effect ed, is according to Natubop laws in general. 33 locks lash at once an entire dissolution of the bands of government, and the people are thereby reduced to a state of anarchy, with liberty to constitute to themselves a new legislative power. Having thus cursorily considered the three usual species of government, and our own singular constitution, selected and compounded from them all, I proceed to observe, that, as the power of making laws constitutes the supreme authority, so wherever the supreme authority in any state resides, it is the right of that authority to make laws, that is, in the words of our definition, to prescribe tili rule of civil action. And this may be discovered from the very end and institution of civil states. For a state is a collective body, composed of a multitude of individuals, united for their safety and convenience and intending to act together as one man. If it therefore is to act as one man, it ought to act by one uniform will. But inasmuch as political communities are made up of many natural persons, each of whom has his particular will and inclination, these several wills cannot by any natural union be joined together, or tempered and disposed into a lasting harmony, so as to constitute and produce that one uniform will of the whole. It can therefore be no otherwise produced than by a political union, by the consent of all persons to submit their OVN private wills to the will of one man, or of one or more assemblies of men, to whom the supreme authority is entrusted. And this will of that one man, or assemblage of men, is in tli states, according to their different constitutions, understood to be law. Thus far as to the right of the supreme power to make laws, but farther it is its duty likewise. For since the respective members are bound to conform themselves to the will of the state, it is expedient that they receive directions from the state declaratory of that its will. But as it is impossible, in so groat a multitude, to give injunctions to every particular man, relative to each particular action, it is therefore incumbent on the state to establish general rules for the perpetual information and direction of all persons in all points, whether of positive or negative duty. And this, in order that every man may know what to look upon as his own, what is another's, what absolute and what relative duties are required at his hands, what is to be esteemed honest, dishonest, or indifferent, what degree every man retains of his natural liberty, what he has given up as the On Government, Part 2, Section 212. Vol. I. In general. Price of the benefits of society, and after what manner each person is to moderate the use and exercise of those rights which the state assigns him, in order to promote and secure the public tranquility. From what has been advanced, the truth of the former branch of our definition is sufficiently evident, that municipal law is a rule of civil conduct prescribed by the supreme power in a state. I proceed now to the latter branch of it, that it is a rule so prescribed, commanding what is right, and prohibiting what is wrong. Now, in order to do this completely, it is first of all necessary that the boundaries of right and wrong be established and ascertained by law. And when this is once done, it will follow of course that it is likewise the business of the law, considered as a rule of civil conduct, to enforce these rights, and to restrain or redress these wrongs. It remains, therefore, only to consider in what manner the law is said to ascertain the boundaries of right and wrong, and the methods which it takes to command the one and prohibit the other. For this purpose every law may be said to consist of several parts. 1. Declaratory, whereby the rights to be observed and the wrongs to be eschewed are clearly defined and laid down. Another, directory, whereby the subject is instructed and enjoined to observe those rights and to abstain from the commission of those wrongs. A third, remedial, whereby a method is jointed out to recover a man's private rights or redress his private wrongs, to which may be added a fourth, usually termed the sanction, or vindicatory branch of the law, whereby it is signified what evil or penalty shall be incurred by such as commit any public wrongs and transgress or neglect their duty. With regard to the first of these, the declaratory part of the municipal law, this depends not so much upon the law of revelation or of nature, as upon the wisdom and will of the legislator. This doctrine, which before was slightly touched, deserves a more particular explanation. Those rights, then, which God and nature have established, and are therefore called natural rights, such as our life and liberty, need not the aid of human laws to be more effectually invested in every man than they are, neither do they receive any additional strength when declared by the municipal laws to be inviolable. On the contrary, no human legislature has power to abridge or destroy them. I on the nature of laws in general. 35. Unless the owner shall himself commit some act that amounts to a forfeiture, neither do divine or natural duties, such as, for instance, the worship of God, the maintenance of children, and the like, receive any stronger sanction from being also declared to be duties by the law of the land. The case is the same as to crimes and misdemeanors that are forbidden by the superior laws and therefore styled mala in C, such as murder, theft, and perjury, which contract no additional turpitude from being declared unlawful by the inferior legislature. For that legislature in all these cases acts only, as was before observed, in subordination to the great lawgiver transcribing and publishing his precepts, so that, upon the whole, the declaratory part of the municipal law has no force or operation at all with regard to actions that are naturally and intrinsically right or wrong. But, with regard to things in themselves indifferent, the case is entirely altered. These become either right or wrong, just or unjust, duties or misdemeanors, according as the municipal legislator sees proper, for promoting the welfare of the society and more effectually carrying on the purposes of civil life. Thus our own common law has declared that the goods of the wife do instantly upon marriage become the property and right of the husband, and our statute law has declared all monopolies a public offense. Yet that right and this offense have no foundation in nature, but are merely created by the law, for the Purity says of civil society, and sometimes where the thing itself has its rise from the law of nature, the particular circumstances and mode of doing it become right or wrong, as the laws of the land shall direct. Thus, for instance, in civil duties, obedience to superiors is the doctrine of revealed as well as natural religion. But who those superiors shall be, and in what circumstances or to what degree they shall be obeyed, it is the province of human laws to determine. And so, as to injuries or crimes, it must be left to our own legislature to decide in what cases the seizing another's cattle shall amount to a trespass or a theft, and where it shall be a justifiable action, as when a landlord takes them by way of distress for rent. Thus much for the declaratory part of the municipal law. And the directory stands much upon the same footing, for this virtually includes the former, the declaration being usually collected from the direction. The law that says, "Thou shalt not steal," implies a declaration that stealing is a crime. And as D. we have seen already, in things naturally indifferent, the very essence of right and wrong depends upon the direction of the laws to do or to omit them. The remedial part of the law is so necessary a consequence of the former too, that laws must be very vague and imperfect without it. For in vain would rights be declared, in vain directed to be observed, if there were no method of recovering and asserting those rights, when wrongfully withheld or invaded. This is what we mean properly, when we speak of the protection of the law. When, for instance, the declaratory part of the law has said that the field or inheritance, which belonged to Titius's father, is vested by his death in Titius, and the directory part has forbidden any one to enter on another's property without the leave of the owner. If Canes, after this, will presume to take possession of the land, the remedial part of the law will then interpose its office, will make Gaines restore the possession to Titius, and also pay him damages for the invasion. With regard to the sanction of laws or the evil that may attend the breach of public duties, it is observed that human legislators have for the most part chosen to make the sanction of their laws vindicatory rather than remuneratory, or to consist rather in punishments than in actual particular rewards. Because, in the first place, the quiet enjoyment and protection of all our civil rights and liberties, which are the sure and general consequence of obedience to the municipal law, are in themselves the best and most valuable of all rewards. Because also, were the exercise of every virtue to be enforced by the proposal of particular rewards, it were impossible for any state to furnish stock enough for so profuse a bounty. And further, because the dread of evil is a much more forcible principle of human action than the prospect of good. For which reasons, though a prudent bestowing of rewards is sometimes of exquisite use, yet we find that those civil laws, which enforce and enjoin our duty, do seldom, if ever, propose any privilege or gift to such as obey the law, but do constantly come armed with a penalty denounced against transgressors, either expressly defining the nature and quantity of the punishment, or else leaving it to the discretion of the judges, and those who are entrusted with the care of putting the laws in execution. Of all the parts of the law the most effectual is the vindicatory. For it is but lost labor to say, do this or avoid that, unless. On the natic of laws in general. 37 We also declare, this shall be the consequence of your non-compliance. We must therefore observe that the main strength and force of a law consists in the penalty annexed to it. Herein is to be found the principal obligation of human laws. Legislators and their laws are said to compel and delige, not that by any natural violence they so constrain a man as to render it impossible for him to act otherwise than as they direct, which is the strict sense of obligation, but because, by declaring and exhibiting a penalty against offenders, they bring it to pass that no man can easily choose to transgress the law, since, by reason of the impending correction, compliance is in a high degree preferable to disobedience. And, even where rewards are proposed as well as punishments threatened, the obligation of the law seems chiefly to consist in the penalty, for rewards, in their nature, can only persuade and allure. Nothing is compulsory but punishment. It is true, adds Sir W. Blackstone, that it has been held, and very justly, by the principle of our ethical writers that human laws are binding upon men's consciences. But if that were the only or most forcible obligation, the good only would regard the laws, and the bad would set them at defiance. And true as this principle is, it must still, Ho proceeds, be understood with some restriction. It holds, he says, as to rights, and that, when the law has determined the field to belong to Titius, it is matter of conscience no longer to withhold or to invade it. So also in regard to natural duties and such offences as are aduilla in C. Here we are bound in conscience, because we are bound by superior laws, before those human laws were in being, to perform the one, and abstain from the other. But in relation to those laws which enjoin only positive duties and forbid only such things as are not mala in C, but mala prohibita merely without any intermixture of moral guilt, annexing a penalty to non-compliance, here, Sir W. Blackstone suggests, conscience is no farther concerned than by directing a submission to the penalty. In these oases, he says, the alternative is offered to every man. Either abstain from this, or submit to such a penalty, and his conscience will be clear, whichever side of the alternative he thinks proper to embrace. This proposition the learned commentator illustrates by a reference to the game laws, whereby a penalty was denounced against every unqualified person that killed a hare, just as by other statutes, now happily repealed, pecuniary penalties were inflicted for exercising trades without serving an apprenticeship thereto, and for not burgering the dead in woolen. These prohibitory laws, Ho contends, do not make the transgression a moral offense or sin, and the only obligation in conscience is, he says, to submit to the penalty if levied. But the same reasoning, it is observed, would justify a bishop in deceiving the ecclesiastical commissioners as to the value of the estates of his see, a merchant or banker in making a false return of his income, and a publican in adulterating his beer, or tradesman the wares in which they deal. And the learned commentator seems to have felt this difficulty, for he adds, we are here speaking of laws that are simply and purely penal, where the thing forbidden. Of laws in general, I have now gone through the definition laid down of a municipal law, and have shown that it is a rule of civil conduct, prescribed by the supreme power in a state commanding what is right and prohibiting what is wrong, in the explanation of which I have endeavored to interweave a few useful principles concerning the nature of civil government and the obligation of human laws. Before I conclude this section, it may not be amiss to add a few observations concerning the interpretation of laws. When any doubt arose upon the construction of the Roman laws, the usage was to state the case to the emperor in writing, and take his opinion upon it. This was certainly a bad method of interpretation. To interrogate the legislature to decide particular disputes is not only endless, but affords great room for partiality and oppression. The answers of the emperor were called his rescripts, and these had in succeeding cases the force of perpetual laws, though they ought to be carefully distinguished by every rational civilian from those general constitutions which had only the nature of things for their guide. The Emperor Macrinus, as his historian Capitolinus informs us, had once resolved to abolish these rescripts, and retain only the general edicts. He could not bear that the hasty and crude answers of such princes as Commodus and Caracalla should be reverenced as laws. But Justinian thought otherwise, and he has preserved them all. In like manner the canon laws, or decretal epistles of the popes, are all of them rescripts in the strictest sense. Contrary to all true forms of reasoning, they argue from particulars to generals. The fairest and most rational method to interpret the will of the legislator is by exploring his intentions at the time when the law was made by signs the most natural and probable. And these signs are either the words, the context, the subject matter, the effects and consequence, or the spirit and reason of them all. Let us take a short view of them all. Or enjoined is wholly a matter of and not hold good. The extent of the difference, and where the penalty in obligation of human laws is fully exemplified, is an adequate compensation for Ned by Jeremy Taylor. Rule of civil inconvenience supposed to arise science, b. 3c. 1. From the offense. Reasoning which will. Inst. 1. Words are generally to be understood in their usual and most known signification, not so much regarding the propriety of grammar, as their general and popular use. Thus the law mentioned by Puffendorf Trey W. Leach forbade a layman to lay hands on a priest, was adjudged to extend to him who had hurt a priest with a weapon. Again, terms of art, or technical terms, must be taken according to the acceptation of the learned in each art, trade, and science. So in the Act of Settlement, where the crown of England is limited to the Princess Sophia and the heirs of her body being Protestants, it becomes necessary to call in the assistance of lawyers to ascertain the precise idea of the words heirs of her body, which in a legal sense comprise only certain of her lineal descendants. 2. If words happen to be still dubious, we may establish their meaning from the contaud, with which it may be of singular use to compare a word or a sentence, whenever they are ambiguous, equivocal, or intricate. Thus the preamble is often called in to help the construction of an Act of Parliament. Of the same nature and use is the comparison of a law with other laws, that are made by the same legislator, that have some affinity with the subject, or that expressly relate to the same point. Thus, when the law of England declared murder to be felony without benefit of clergy, it was necessary to resort to the same law of England to learn what the benefit of clergy was. And, when the common law centers simoniacal contracts, it affords great light to the subject to consider what the canon law has adjudged to be simony. 3. As to the subject matter, words are always to be understood as having a regard thereto, for that is always supposed to be in the eye of the legislator, and all his expressions directed to that end. Thus, when a law of our Edward Roman III forbids all ecclesiastical persons to purchase provisions at Rome, it might seem to prohibit the buying of grain and other victual, but when we consider that the statute was made to repress the usurpations of the papal see, and that the nominations to benefices by the Pope were called provisions, we shall see that the restraint is intended to be laid upon such provisions only. 4. As to the effects and consequence, the rule is, that where eleven and n. 5:12:3. The nadu of laws in general. Words bear either none, or a very absurd signification. If literally understood, we must a little deviate from the received sense of them. Therefore the Bolognian law, which enacted that who ever drew blood in the streets should be punished with the utmost severity, was held after a long debate not to extend to the surgeon who opened the vein of a person that fell down in the street with a fit. 5. But, lastly, the most universal and effectual way of discovering the true meaning of a law, when the words are dubious, is by considering the reason and spirit of it, or the cause which moved the legislature to enact it. For when this reason ceases, the law itself ought likewise to cease with it. An instance of this is given in a case put by Cicero, or whoever was the author of the treatise inscribed to Hieronius. There was a law, that those who in a storm forsook the ship should forfeit all property therein, and that the ship and lading should belong entirely to those who stayed in it. In a dangerous tempest all the mariners forsook the ship, except only one sick passenger, who by reason of his disease was unable to get out and escape. By chance the ship came safe to port. The sick man kept possession, and claimed the benefit of the law. Now here all the learned agree, that the sick man is not within the reason of the law, for the reason of making it was to give encouragement to such as should venture their lives to save the vessel. But this is a merit which he could never pretend to, who neither stayed in the ship upon that account, nor contributed anything to its preservation. From this method of interpreting laws, by the reason of them, arises what has been termed the equity of a statute, which is thus defined by Grotius I. The correction of that wherein the law, by reason of its universality, is deficient. For, since in laws all cases cannot be foreseen or expressed, it is necessary that when the general decrees of the law come to be applied to particular cases, there should be somewhere a power vested of defining those circumstances which, had they been foreseen, the legislator himself would have expressed. And these are the decrees Puffendorf, L. 5c. 12s. 8 fire, for he is not to be hanged because decrees the stat. Deferring gentibus pionum, he would not stay to be burnt. Plow 1 edwa. Roman 2, which enacts that a prisoner dens rep. p. 13. Who breaks prison shall be guilty of pl. 1 c. 11. Felony does not extend to a prisoner I de emquitate s. Free. Who breaks out when the prison. On the nature of laws in general. 41 cases which, according to Grotius Zege non exacti degenet, said, arbitrio honi viri permittit. Equity thus depending, essentially, upon the particular circumstances of each individual case, there can be no established rules and fixed precepts of equity laid down, without destroying its very essence and reducing it to a positive law. And, on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law, and leave the decision of every question entirely in the breast of the judge. And law, without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator, and introduce most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. Section Roman 3. The Laws of England. The municipal law of England, or the rule of civil conduct prescribed to the inhabitants of this kingdom, may with sufficient propriety be divided into two kinds: the lex non scripta, the unwritten or common law, and the lex scripta, the written or statute law. The lex non scripta, or unwritten law, includes not only general customs, or the common law properly so called, but also the particular customs of certain parts of the kingdom, and likewise those particular laws that are by custom observed only in certain courts and jurisdictions. When I call these parts of our law leges non scripti, I would not be understood as if all those laws were at present merely oral, or communicated from former ages to the present solely by word of mouth. It is true indeed that, in the profound ignorance of letters which formerly overspread the whole Western world, all laws were entirely traditional, for this plain reason, because the nations among which they prevailed had but little idea of writing. Thus the British as well as the Gallic Druids committed all their laws as well as learning to memory, and it is said of the primitive Saxons here, as well as their brethren on the continent, that leges soled memorid et usuratimbent dot, but with us, at present, the monuments and evidences of our legal customs are contained in the records of the several courts of justice, in books of reports and judicial decisions, and in the treatises of learned sages of the profession, preserved and handed down to us from the times of highest antiquity. I, therefore, style these parts of our law leges non scripti, because their original institution and authority are not set down in writing, as acts of parliamentar, but they receive their binding power, and the CFS de B. D. Lib. 6c. 13. Spelm. GL. The Laws of England. 43 Force of laws by long and immemorial usage, and by their universal reception throughout the kingdom. In like manner as Aulus Gellius defines the jus non scriptum to be that which is tacito et literato hominum consensu et mortibus expressum. Our ancient lawyers, and particularly Fortescue, insist with abundance of warmth that these customs are as old as the primitive Britons and continue down, through the several mutations of governments and inhabitants, to the present time, unchanged and unadulterated. This may be the case as to some, but in general, as Selden in his notes observes, this assertion must be understood with many grains of allowance, and ought only to signify, as the truth seems to be, that there never was any formal exchange of one system of laws for another. Though the Bomans, the Picts, the Saxons, the Danes, and the Normans, who successively occupied parts of England, must have insensibly introduced and incorporated many of their own customs with those that were before established, thereby in all probability improving the texture and wisdom of the whole by the accumulated wisdom of divers particular countries. Our laws, says Lord Bacon, are mixed as our language. And as our language is so much the richer, the laws are the more complete. And indeed our antiquaries and early historians do all positively assure us that our body of laws is of this compounded nature, for they tell us that in the time of Alfred the local customs of the several provinces of the kingdom were grown so various, that he found it expedient to compile his Domhoek, or Liber Judicialis, for the general use of the whole kingdom. This book is said to have been extant so late as the reign of King Edward IV, but is now unfortunately lost. It contained, we may probably suppose, the principal maxims of the common law, the penalties for misdemeanors, and the forms of judicial proceedings. Thus much may at least be collected from that injunction to observe it, which we find in the laws of King Edward the Elder, the son of Alfred. King Edward commands all the reeves that ye judge such justims as ye know to be most righteous, and it in the Doom Book, Saxonis, Bombach, stands, fear not on any account to pronounce folk right. Saxonis, Polk pair, and that every suit have a term when it shall be brought forward, that ye then may pronounce. Asterisk. See, however, Thorpe's preface to the have been not to the laws of Alfred, but ancient laws and institutes of England. To the earlier dooms of an A. Thorpe. The reference to the Doom Book. The laws of England. But the eruption and establishment of the Danes in England, which followed soon after, introduced new customs and caused this code of Alfred in many provinces to fall into disuse, or at least to be mixed and debased with other laws of a coarser alloy. So that about the beginning of the 11th century there were three principal systems of laws prevailing in different districts. 1. The Mercenlage, or Mercian laws, which were observed in many of the Midland counties and those bordering on the Principality of Wales, the retreat of the ancient Britons, and therefore very probably intermixed with the British or Druidical customs. 2. The West Saxon Lage, or laws of the West Saxons, which obtained in the counties to the south and west of the island, from Kent to Devonshire. These were probably much the same with the laws of Alfred above mentioned, being the municipal law of the far most considerable part of his dominions, and particularly including Berkshire, the seat of his peculiar residence. 3. The Danelage, or Danish law, the very name of which speaks its origin and composition. This was principally maintained in the rest of the Midland counties, and also on the eastern coast, the part most exposed to the visits of that piratical people. As for the very northern provinces, they were at that time under a distinct government. Out of these three laws, Eadger Hovden and Enolphus Estrensis inform us. King Edward the Confessor extracted one uniform law or digest of laws to be observed throughout the whole kingdom, though Hovden and the author of an old manuscript chronicle assure us likewise that this work was projected and begun by his grandfather King Edgar. And indeed a general digest of the same nature has been constantly found expedient, and therefore put in practice by other great nations, which were formed from an assemblage of little provinces governed by peculiar customs. As in Portugal, under King Edward, about the beginning of the 15th century, in Spain, under Alonso X who, about the year 1250, executed the plan of his father son, Ferdinand, and collected all the provincial customs into one uniform law in the celebrated code entitled Las Partidas. And in Sweden, about the same era when a Unihal, Hist. 55. Are spurious. Hal. Me. Ag Roman 2. 321, n. The extant remains of these laws in Seld. A. Eadmer, d. as set forth in Lambard and Wilkins. The 45-versal body of common law was compiled out of the particular customs established by the lagman of every province, and entitled the Lance's Log, being analogous to the common law of England. Both these undertakings of King Edgar and Edward the Confessor seem to have been no more than a new edition, or fresh promulgation of Alfred's Code or Dome Book, with such additions and improvements as the experience of a century and a half had suggested. For Alfred is generally styled by the same historians the Legum Anglicanarum Conditor, as Edward the Confessor is the Restitutor. These, however, are the laws which our historians so often mention under the name of the laws of Edward the Confessor, which our ancestors struggled so hardly to maintain under the first princes of the Norman line, and which subsequent princes so frequently promised to keep and restore, as the most popular act they could do, when pressed by foreign emergencies or domestic discontents. These are the laws that so vigorously withstood the repeated attacks of that civil law, which established in the 12th century a new Roman Empire over most of the states of the continent, states that have lost, and perhaps upon that account, their political liberties, while the free constitution of England, perhaps upon the same account, has been rather improved than debased. These, in short, are the laws which gave rise to that collection of maxims and customs which is now known by the name of the common law, a name either given to it in contradistinction to other laws as the statute law, the civil law, the law merchant, and the like, or more probably, as a law common to all the realm, the just commune or folk right mentioned by King Edward the Elder, after the abolition of the several provincial customs and articular laws before mentioned. But though this is the most likely foundation of this collection of maxims and customs, yet the maxims and customs so collected are of higher antiquity than memory or history can reach, nothing being more difficult than to ascertain the precise beginning and first spring of an ancient and long-established custom. Whence it is that in our law the goodness of a custom depends upon its having been used time out of mind, or in the solemnity of our legal phrase, time whereof the memory of man runneth not to the contrary. This it is that gives it its weight and authority, and the laws of England. Of this nature are the maxims and customs which compose the common law, or lex non scripta, of this kingdom. This unwritten or common law is properly distinguishable into three kinds. 1. General customs, which are the universal rule of the whole kingdom, and form the common law in its stricter and more usual signification. 2. Particular customs, which for the most part affect only the inhabitants of particular districts. 3. Certain particular laws, which by custom are adopted and used by some particular courts of pretty general and extensive jurisdiction. 1. As to general customs, or the common law, properly so called, this is that law by which proceedings and determinations in the ordinary courts of justice are guided and directed. This, for the most part, settles the course in which lands descend by inheritance, the manner and form of acquiring and transferring property, the solemnities and obligation of contracts, the rules of expounding wills, deeds, and acts of Parliament, the respective remedies of civil injuries, the several species of temporal offences, with the manner and degree of punishment, and an infinite number of minute particulars, which diffuse themselves as extensively as the ordinary distribution of common justice requires. Thus, for example, that the eldest son alone is heir to his ancestor, that property may be acquired and transferred by writing, that a deed is of no validity unless sealed and delivered, that wills shall be construed more favorably, and deeds more strictly, that money lent upon bond is recoverable by action of debt, that breaking the public peace is an offense and punishable by fine and imprisonment. All these are doctrines that are not set down in any written statute or ordinance, but depend merely upon immemorial usage, that is, upon common law, for their support. Some have divided the common law into two principal grounds or foundations. 1. Established customs, such as that, where there are 3 brothers, the eldest brother shall be heir to the second, in exclusion of the youngest, and 2. Established rules and maxims, as that the king can do no wrong, that no man shall be bound to accuse himself, and the like. But I take these to be one and the same thing. For the authority of these maxims rests entirely upon general reception and usage, and 47. Only method of proving that this or that maxim is a rule of the common law is by showing that it has been always the custom to observe it. But here a very natural and very material question arises: how are these customs or maxims to be known, and by whom is their validity to be determined? The answer is, by the judges in the several courts of justice. They are the depositaries of the laws, the living oracles, who must decide in all cases of doubt, and who are bound by an oath to decide according to the law of the land. Their knowledge of that law is derived from experience and study, from the Viginti Anorum Humbrioes, which Fortescue mentions, and from being long personally accustomed to judicial decisions of their predecessors. And indeed these judicial decisions are the principal and most authoritative evidence that can be given of the existence of such a custom as shall form a part of the common law. The judgment itself, and all the proceedings previous thereto, are carefully registered and preserved under the name of records, in public repositories set apart for that particular purpose, and to them frequent recourse is had, when any critical question arises in the determination of which former precedents may give light or assistance. And therefore, even so early as the Conquest, we find the Penetrator Memoria Eventorum reckoned up as one of the chief qualifications of those who are held to be legibus patitsi optime instituti. For it is an established rule to abide by former precedents, where the same points come again in litigation, as well to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion, as also because the law in that case being solemnly declared and determined, what before was uncertain and perhaps indifferent, is now become a permanent rule which it is not in the breast of any subsequent judge to alter or vary from, according to his private sentiments, he being sworn to determine, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one. Yet this rule admits of exception, where the former determination is most evidently contrary to reason, much more if it be clearly contrary to the divine law. But even in such cases the subsequent judges do not pretend to make a new law, but to vindicate the old one from Cell. Review of Tithes c. 8. Misrepresentation. For if it be found that the former decision is manifestly absurd or unjust, it is declared not that such a sentence was at law, but that it was not law, that is, that it is not the established custom of the realm, as has been ausleiterment. And hence it is that our lawyers are with justice so copious in their encomiums on the reason of the common law, that they tell us that the law is the perfection of reason, that it always intends to conform thereto, and that what is not reason is not law. Not that the particular reason of every rule in the law can at this distance of time be always precisely assigned, but it is sufficient that there be nothing in the rule flatly contradictory to reason, and then the law will presume it to be well-founded. The doctrine of the law then is this: that precedents and rules must be followed, unless flatly absurd or unjust, for though the reason be not obvious at first view, yet we owe such a deference to former times as not to suppose that they acted wholly without consideration. To illustrate this doctrine by an example, it was determined, time out of mind, that a brother of the half-blood should never succeed as heir to the estate of his half-brother, but it should rather escheat to the crown, or other superior lord. Now this was a positive law, fixed and established by custom, which custom was evidenced by judicial decisions, and therefore could never be departed from by any judge without a breach of his oath and the law. For therein there was nothing repugnant to natural justice, though the artificial reason of it, drawn from the feudal law, might not be quite obvious to everybody. And therefore, though a modern judge, on account of a supposed hardship upon the half-brother, might have wished it had been otherwise settled, yet it was not in his power to alter it. It was the legislature alone which could and did alter the common law in this respect. The law and the opinion of the judge, therefore, are not always convertible terms or one and the same thing, since it sometimes may happen that the judge may mistake the law, but upon the whole, we may take it as a general rule that the decisions of courts of justice are the evidence of what is common law. In the same manner as, in the civil law, what the emperor had once determined was to serve for a guide for the future. Herein agreeing with the civil law, J3 and 4 will 4C 196 S 9 FF 1 Free 2021 0 1 14 12 Op the laws of England. 49 The decisions, therefore, of courts are held in the highest regard, are not only preserved as authentic records in the treasuries of the several courts, but are handed out to public view in the numerous volumes of reports which furnish the lawyer's library. These reports are histories of the several cases, the arguments on both sides, and the reasons the court gave for its judgment, taken down by persons present at the determination, and these serve as indexes to, and also to explain, the records, which always, in matters of consequence and nicety, the judges direct to be searched. The reports are extant in a regular series from the reign of King Edward II inclusive, and from this time to that of Henry VIII were taken by the prothenotaries, or chief scribes of the court, at the expense of the crown, and published annually, whence they are known under the denomination of the yearbooks. And it is much to be wished that this beneficial custom had, under proper regulations, been continued to this day. For, though King James I, at the instance of Lord Bacon, appointed 2 reporters, with a handsome stipend for this purpose, yet that wise institution was soon neglected, and from the reign of Henry VIII to the present time this task has been executed by many private and contemporary hands, who, sometimes through haste and inaccuracy, sometimes through mistake and want of skill, have published very crude and imperfect, perhaps contradictory, accounts of one and the same determination. Some of the most valuable of the ancient reports are those published by Lord Chief Justice Coke, a man of infinite learning in his profession, though not a little infected with the pedantry and quaintness of the times he lived in, which appear strongly in all his works. However, his writings are so highly esteemed that they are generally cited without the author's name. Trade. Besides these reporters, there are also other authors to whom great veneration and respect is paid by the students of the common law. Such are Glanville and Bracton, Britton and Fleta, Hengham and Littleton, Statham, Brooke, Fitzherbert, and Staunford, with some others of ancient date, whose treatises Pat. 15 Jack, I. P. 18. 17 Rim. 26, are also cited in a peculiar manner by his reports. For instance, are styled the names of those princes in whose I oxive he reports, and in quoting Raines the cases reported in his three them we usually say, 1 or 2 rep not volumes were determined, viz. Crow, Eliz, 1 or 2 Coke's rep as in citing other Crow. Jack and Crow, Carr. Authors. The reports of Judge Croke-Viol. 50 op the laws of England are cited as authority, and are evidence that cases have formerly happened in which such and such points were determined, which are now become settled and first principles. One of the last of these methodical writers in point of time, whose works are of any intrinsic authority in the courts of justice and do not entirely depend on the strength of their quotations from older authors, is the same learned judge we have just mentioned, Sir Edward Coke, who has written 4 volumes of Institutes, as he is pleased to call them, though they have little of the institutional method to warrant such a title. The first volume is a very extensive comment upon a little excellent treatise of tenures, compiled by Judge Littleton, in the reign of Edward IV. This comment is a rich mine of valuable common law learning, collected and heaped together from the ancient reports and yearbooks, but greatly defective in method. The second volume is a comment upon many old Acts of Parliament, without any systematic order. The third, a more methodical treatise of the pleas of the Crown, and the fourth, an account of the several species of courts. And thus much for the first ground and chief cornerstone of the laws of England, which is general immemorial custom or common law, declared from time to time in the decisions of the courts of justice, which decisions are preserved among our public records, explained in our reports, and digested for general use in the authoritative writings of the venerable sages of the law. The Yeoman law, as practiced in the times of its liberty, paid also a great regard to custom, but not so much as our law, it only then adopting it when the written law was deficient, though the reasons alleged in the digest will fully justify our practice in making it of equal authority with, when it is not contradicted by, the written law. For since, says Julianus, the written law bnds us for no other reason but because it is approved by the judgment of the people, therefore those laws which the people have approved without writing ought also to bind every. It is usually cited either by the no other writer. Early reports are Genem of Co. Lit. Or as one inst. Raleigh quoted in the name of the compiler. These are cited as 2, 3, or 4 inst. As 2 Ventris, 4 Leonard, 1 Ciderfin, and without any author's name. An honorary the like distinction which is paid to the works of body. For where is the difference, whether the people declare their assent to a law by suffrage, or by a uniform course of acting accordingly? Thus did they reason while Rome had some remains of her freedom, but when the imperial tyranny came to be fully established, the civil laws speak a very different language. Cui ad J principi placuit leges hahit vigorum, cumge populus. I, et in eum, omni suum imperium et potestatem conferet, says Ulpian. Imperator salus et iunditor et interpres leges existi. Mature, says the Code. And again, sacrilegi in star est. Rescriptio prinipes oviri. And indeed it is one of the characteristic marks of English liberty, that our common law depends upon custom, which carries this internal evidence of freedom along with it, that it probably was introduced by the voluntary consent of the people. Roman 2. The second branch of the unwritten laws of England are particular customs, or laws which affect only the inhabitants of particular districts. These particular customs, or some of them, are without doubt the remains of that multitude of local customs before mentioned, out of which the common law, as it now stands, was collected at first by the Saxon kings. But for reasons that have been now long forgotten, particular counties, cities, towns, manors, and lordships were very early indulged with the privilege of abiding by their own customs in contradistinction to the rest of the nation at large, which privilege is confirmed to them by several acts of Parliament. Such as the custom of Gavekind in Kent and some other parts of the kingdom, though perhaps it was also general till the Norman conquest, which ordains, among other things, that not the eldest son only of the father shall succeed to his inheritance, but all the sons alike. And that, though the ancestor be attainted and hanged, yet the heir shall succeed to his estate, without any escheat to the lord. Such is the custom that prevails in divers ancient boroughs, and therefore called borough English, that the youngest son shall inherit the estate in preference to all his elder brothers. Such is the custom in other boroughs that a widow shall be entitled, for her dower, to all her husband's lands. 1 ff. 141 * mag. Cart. 9 hen. Roman 3. c. 9. 1 edawok. c. 1 14 12. m. sin. 2 c. 9. 14 edawok. Roman 3. sin. 1 c. 1 c. 1 23 5. and 2 hen. Roman 4. c. 52 of the laws of England, whereas at the common law she shall be endowed of 1/3 part only. Such also are the special and particular customs of manors, of which every one has more or less, and which bind all the copyhold and customary tenants that hold of the same manors. Such likewise is the custom of holding divers inferior courts, with power of trying causes in cities and trading towns, the right of holding which, when no royal grant can be shown, depends entirely upon immemorial and established usage. Such, lastly, are many particular customs within the city of London, with regard to trade, apprentices, widows, orphans, and a variety of other matters. All these are contrary to the general law of the land, and are good only by special usage, though the customs of London are also confirmed by Act of Parliament. To this head may most properly be referred a particular system of customs used only among one set of the Queen's subjects, called the custom of merchants, or lex mercatoria, which, however different from the general rules of the common law, is yet engrafted into it, and made a part of it, being allowed, for the benefit of trade, to be of the utmost validity in all commercial transactions. For it is a maxim of law, that Ulihit in su art credendum est. The rules relating to particular customs regard either the proof of their existence, their legality when proved, or their usual method of allowance. And first we will consider the rules of proof. As to Gavekind and borough English, the law takes particular notice of them, and there is no occasion to prove that such customs actually exist, but only that the lands in question are subject thereto. All other private customs must be particularly pleaded, and as well the existence of such customs must be shown as that the thing in dispute is within the custom alleged. The trial in both cases, both to show the existence of the custom, as that in the manor of Dale lands shall descend only to the heirs male and never to the heirs female, and also to show that the lands in question are within that manor, is by a jury of 12 men, and not by the judges, except the same particular custom has been before tried, determined, and recorded in the same court. The customs of London differ from all others in point of trial. The laws of England. 53. For if the existence of the custom be brought in question, it shall not be tried by a jury, but by certificate from the Lord Mayor and aldermen by the mouth of the recorder, unless it be such a custom as the corporation is itself interested in, as a right of taking toll, and for then the law permits them not to certify on their own behalf. When a custom is actually proved to exist, the next inquiry is into the legality of it, for, if it is not a good custom, it ought to be no longer used. Malus usus abolendus cst. is an established maxim of the law. To make a particular custom good, the following are necessary requisites. 1. That it have been used so long, that the memory of man ninneth not to the contrary, so that if any one can show the beginning of it, it is no good custom. For which reason no custom can prevail against an express act of Parliament, since the statute itself is a proof of a time when such a custom did not exist. 2. It must have been continued. Any interruption would cause a temporary ceasing. The revival gives it a new beginning, which will be within time of memory, and thereupon the custom will be void. But this must be understood with regard to an interruption of the right, for an interruption of the possession only, for 10 or 20 years, will not destroy the custom, as if the inhabitants of a parish have a customary right of watering their cattle at a certain pool, the custom is not destroyed, though they do not use it for 10 years, it only becomes more difficult to prove. But if the right be anyhow discontinued for a day, the custom is quite at an end. 3. It must have been peaceable, and acquiesced in, not subject to contention and dispute. For as customs owe their origin to common consent, their being immemorially disputed, either at law or otherwise, is a proof that such consent was wanting. 4. Customs must be reasonable, or rather, taken negatively, they must not be unreasonable, which is not always to be understood of every unlearned man's reason, but of artificial and legal reason, warranted by authority of law, upon which account a custom may be good, though the particular reason of it cannot be assigned, for it suffices if no good legal reason can be assigned against it. Thus a custom in a parish that no man shall put his beasts into the common till the 3rd of October would be good, and yet it would be hard to show the reason why that day in particular is fixed upon, rather than the day before or after. But a custom, that no cattle shall be put in till the lord of the manor has first put in his, is unreasonable, and therefore bad, for peradventure the lord will never put in his, and then the tenants will lose all their profits. So a custom for all the inhabitants of a parish to angle and catch fish in a river on the property of another is bad, because it might lead to the destruction of the subject matter to which the alleged custom applied. 5. Customs ought to be certain. A custom, that lands shall descend to the most worthy of the owner's blood, is void, for how shall this worth be determined? But a custom to descend to the next male of the blood, exclusive of females, is certain, and therefore good. A custom to pay 2d. an acre, in lieu of tithes, is good, but to pay sometimes 2d. and sometimes 3d., as the occupier of the land pleases, is bad for its uncertainty. Yet a custom to pay a year's improved value for a fine on a copyhold estate is good, though the value is a thing uncertain, for the value may at any time be ascertained, and the maxim of law is id serium est, quod serium redi potest. 6. Customs, though established by consent, must be, when established, compulsonge, and not left to the option of every man, whether he will use them or no. Therefore a custom, that all the inhabitants shall be rated toward the maintenance of a bridge, will be good. But a custom that every man is to contribute thereto at his own pleasure is idle and absurd, and indeed no custom at all. 7. Lastly, customs must be consistent with each other. One custom cannot be set up in opposition to another. For if both are really customs, then both are of equal antiquity, and both established by mutual consent. Which to say of contradictory customs is absurd. Therefore if one man prescribes that by custom he Bland v. Lipscomb 4 Ellis and Beale, 713 note, I Jice v. Hay, 1 M. Queen's Appeal Cases, 305. Co. U. Aber. 565. Has a right to have windows looking into another's garden, the other cannot claim a right by custom to stop up or obstruct those windows. For these two contradictory customs cannot both be good, nor both stand together. He ought rather to deny the existence of the former custom. Next, as to the allowance of special customs. Customs, in derogation of the common law, must be construed strictly. Thus, by the custom of gavekind, an infant of 15 years may by one species of conveyance called a deed of fiefment convey away his lands in fee simple, or forever. Yet this custom does not empower him to use any other conveyance, or even to lease them for 7 years. for the custom must be strictly pursued. And moreover, all special customs must submit to the royal prerogative. Therefore, if the sovereign purchases lands of the nature of gavekind, where all the sons inherit equally, yet, upon the demise of the crown, the eldest son shall succeed to those lands alone. And thus much for the second part of the leges non scripti, or those particular customs which affect particular persons or districts only. Roman 3. The third branch of the leges non scripti are those peculiar laws which by custom are adopted and used only in certain peculiar courts and jurisdictions. And by these I understand the civil and canon laws. It may seem a little improper at first view to rank these laws under the head of leges non scripti or unwritten laws, seeing they are set forth by authority in ** the Pandect, the Code, and the Institutes, in the decrees of councils and the decretals of popes, and enforced by an immense number of expositions, decisions, and treatises of the learned in both branches of the law. But I do this, after the example of Sir Matthew Hale, * in his History of the Common Law, because it is most plain that it is not on account of their being written laws that either the canon law or the civil law have any obligation within this kingdom, neither do their force and efficacy depend upon their own intrinsic authority, which is the case of our written laws or acts of Parliament. They bind not the subjects of England, because their materials were collected from popes or emperors, were digested by Justinian, or declared to be authentic by Gregory. These the laws of England considerations give them no authority here. For the legislature of England does not, nor ever did recognize any foreign power as superior or equal to it in this kingdom, or as having the right to give law to any, the meanest of its subjects. But all the strength that either the papal or imperial laws have obtained in this realm, or indeed, in any other kingdom in Europe, is only because they have been admitted and received by immemorial usage and custom in some particular cases and some particular courts, and then they form a branch of the leges non scriptum, or customary laws, or else, because they are in some other cases introduced by consent of Parliament, and then they owe their validity to the leges scripti, or statute law. This is expressly declared in those remarkable words of the Statute 25 Hen. Roman 8. c. 21, addressed to the King's Royal Majesty. This your Grace's realm, recognizing no superior under God, but only your Grace, hath been and is free from subjection to any man's laws, but only to such as have been devised, made, and ordained within this realm for the wealth of the same, or to such other as, by sufferance of your Grace and your progenitors, the people of this your realm have taken at their free liberty, by their own consent to be used among them, and have bound themselves by law and use and custom to the observance of the same, not as to the observance of the laws of any foreign prince, potentate, or prelate, but as to the customed and ancient laws of this realm, originally established as laws of the same, by the said sufferance, consents, and custom, and none otherwise. By the civil law, absolutely taken, is generally understood the civil or municipal law of the Roman Empire as comprised in the Institutes, the Digest, and the Code of the Emperor Justinian, and the Novellies, or new constitutions of himself and some of his successors, of which, as there will frequently be occasion to cite them, by way of illustrating our own laws, it may not be amiss to give a short and general account. The Roman law, founded first upon the regal constitutions of their ancient kings, next upon the 12 tables of the decemviri, then upon the laws or statutes enacted by the Senate or people, the edicts of the PR Setter and the Responsa Prudentum, or opinions of learned lawyers, and lastly upon the imperial decrees or constitutions of successive emperors, had grown to so great a Laws 01. England. 57 bulk, or as Livy expresses it, tornamensis alirum super alias servitarum legum cumulus, that they were computed to be many camels. Load by an author who preceded Justinian. This was in part remedied by the collections of 3 private lawyers, Gregorius, Hermogenes, and Papirius, and then by the Emperor Theodosius the Younger, by whose orders a code was compiled, A.D. 438, being a methodical collection of all the imperial constitutions then in force. which Theodosian Code was the only book of civil law received as authentic in the western part of Europe, till many centuries after, and to this it is probable that the Franks and Goths might frequently pay some regard, in framing legal constitutions for their newly erected kingdoms. For Justinian commanded only in the eastern remains of the empire, and it was under his auspices that the present body of civil law was compiled and finished by Tribonian and other lawyers about the year 533. This consists of 1. The Institutes, which contain the elements or first principles of the Roman law, in 4 books. 2. The Digest or Pandect in 50 books containing the opinions and writings of eminent lawyers digested in a systematic method. 3. The Code * or Codex Repetiti Praeselectionis, a collection of imperial constitutions, in 12 books, the lapse of a whole century having rendered the former code of Theodosius imperfect. 4. The Novellies, or New Constitutions, posterior in time to the other books, and amounting to a supplement to the code, containing new decrees of successive emperors as new questions happen to arise. These form the body of Roman law, or Corpus Juris Civilis. The canon law is a body of Roman ecclesiastical law, relative to such matters as that Church either has, or pretends to have, the proper jurisdiction over. This is compiled from the opinions of the ancient Latin Fathers, the decrees of general councils, and the decretal epistles and bulls of the Holy See, all which lay in the same disorder and confusion as the Roman civil law. Till about the year 1151, one Gratian, *, a Benedictine monk of the monastery of St. Thales Epilona, reduced the ecclesiastical constitutions also into some method, in 3 books, which he entitled Concordia Discordantium Canonum, but which are generally known by the name of Edictum Gratiani. These reached as low L. 3c. 34. Taylor's Elements of Civil Law. The Laws of England. As the time of Pope Alexander Roman III. The subsequent papal decrees to the pontificate of Gregory Roman IX were published in much the same method, under the auspices of that pope, about the year 1230, in 5 books, entitled Decretalium D. Gregorii Paps Roman IX. Compilatio, a 6th book was added by Boniface Roman VIII, about the year 1298, which is called Liber Sextus Decretalium D. Bonifaciae Paps Roman VIII. The Clementine Constitutions, or decrees of Clement V, were in like manner authenticated in 1317 by his successor John Roman XXII, who also published 20 constitutions of his own, called the Extravagantes Joannis Roman XXII, all which in some measure answer to the novels of the civil law. To these have been since added some decrees of later popes, in 5 books called Extravagantes Communes. And all these together, Gratian's decree, Gregory's decretals, the Book of 6 decretals, the Clementine constitutions, and the Extravagantes of John and his successors, form the Corpus Juris Canonici, or body of the Eoman canon law. Besides these pontifical collections, which, till the Reformation, were received as authentic in this island as well as in other parts of Christendom, there is also a kind of national canon law, composed of legatine and provincial constitutions and adapted only to the exigencies of this church and kingdom. The legatine constitutions were ecclesiastical laws enacted in national synods held under the cardinals Otho and Othobon, legates from Pope Gregory Roman IX and Pope Clement Roman IV, in the reign of King Henry Roman III, about the years 1220 and 1268. The provincial constitutions are principally the decrees of provincial synods held under divers archbishops of Canterbury, from Stephen Langton in the reign of Henry Roman III to Henry Chichel in the reign of Henry V, and adopted also by the province of York in the reign of Henry VI. At the dawn of the Reformation, in the reign of King Henry Roman VIII, it was enacted in Parliament that a review should be had of the canon law, and, till such review should be made, all canons, constitutions, ordinances, and synodals for a short notice of these different J.G. Phillimore, Quo. London, 1851. Decretals, see Dr. Irving's Introd, to the * constitutions of Otho, with notes by study of the civil law, and Fournay C.J. W. White of Doctors' Commons. Long count of the Edictum Gratiani, and Andon, 1844. Examination of the Antiuance of Ecclesi. Burns Eckel. Law Pref. Roman 8. Astical Law in European Legislation, c. 25 Hen. Roman 8. c. 19. 1 Eliz. c. I. Lectures on Jurisprudence by the Laws op England. 59 Provincial, being then already made, and not repugnant to the law of the land or the royal prerogative, should still be used and executed. And as no such review has yet been perfected, upon this statute now depends the authority of the canon law in England. As for the canons enacted by the clergy under James I in the year 1603, and never confirmed in Parliament, it has been solemnly adjudged, upon the principles of law and the Constitution, that where they are not merely declaratory of the ancient canon law, but are introductory of new regulations, they do not bind the laity, whatever regard the clergy may think proper to pay them. The civil and canon laws are now permitted, under different restrictions, to be used in 1. The courts of the archbishops and bishops and their derivative officers, usually called, in our law, courts Christian, curias Christianitatis, or the ecclesiastical courts. 2. The military courts, and 3. The Chancellor's Court of the University of Cambridge. In all, their reception in general, and the different degrees of that reception, are grounded entirely upon custom *, but the more minute consideration of these will fall properly under that part of these commentaries which treats of the jurisdiction of courts. It will suffice at present to remark a few particulars relative to them all, which may serve to inculcate more strongly the doctrine laid down concerning them. 1. And, first, the courts of common law, now merged in the High Court of Justice, have the superintendence over these courts, to keep them within their jurisdictions, to determine wherein they exceed them, to restrain and prohibit such excess and, in case of contumacy, to punish the officer who executes, and in some cases the judge who enforces, the sentence so declared to be illegal. 1057. We cannot trust the ecclesiastical formerly also in the High Court of Courts to determine what is a matter admiralty, now merged in the High merely spiritual. Per Talbot L. C. Court of Justice, and in the Chancellor's SDR. 1067. X. Jenkins, 1b, and c. 655. Court of the University of Oxford. Borain v. Scott, 3 Camp. And P. J.S. Tope v. Hope, 1 Swaby and Tris Rep. 387. Tram Rep. England. 2. The common law has reserved to itself the exposition of all such acts of Parliament as concern either the extent of these courts, or the matters depending before them. And, therefore, if these courts either refuse to allow these acts of Parliament, or will expound them in any other sense than what the common law puts upon them, the High Court will grant prohibitions to restrain and control them. 3. An appeal lies from all these courts to the sovereign, in the last resort, the jurisdiction exercised by them being in theory derived from the Crown of England, and not from any foreign potentate or intrinsic authority of their own. And, from these 3 strong marks and ensigns of superiority, it appears beyond a doubt that the civil and canon laws, though admitted in some cases by custom in some courts, are only subordinate and leges sub graviare lege, and that, thus admitted, restrained, altered, new-modelled, and amended, they are by no means with us a distinct independent species of laws, but are inferior branches of the customary or unwritten laws of England. Let us next proceed to the leges scriptas, the written laws of the kingdom, which are statutes, acts, or edicts made by the sovereign, by and with the advice and consent of the lords spiritual and temporal, and commons, in Parliament assembled. The oldest of these now extant is the famous Magna Charta, as confirmed in Parliament 9 Henry Roman 3. Though doubtless there were many acts before that time, the records of which are now lost, and the determinations of them perhaps at present currently received for the maxims of the old common law. The manner of making these statutes will be better considered hereafter, when we examine the constitution of parliaments. At present we will only take notice of the different kinds of statutes, and of some general rules with regard to their construction. Hall v. Mall 7a, and E. 72 Statutes of Merton and Marbridge, of 8 20. Westminster, Gloucester, and Winches. The method of citing these acts of ter. Others are denominated entirely Parliament is various. Many of are from their subject, as the statutes of ancient statutes are called after the Wales and Ireland, the articuli clari and name of the place where the Parliament the prerogative regis. Some are diswasheld that made them, as the distinguished by their initial words. Of the laws of England. 61 First, as to their several kinds. Statutes are either general or special, privy or private. A general or public act is an universal rule that regards the whole community. Special or private acts are rather exceptions than rules, being those which only operate upon particular persons and private concerns. Thus, to show the distinction, the Statute 13 is c. 10 to prevent spiritual persons from making leases for longer terms than 21 years or 3 lives is a public act, it being a rule prescribed to the whole body of spiritual persons in the nation. But an act to enable the Bishop of Chester to make a lease to A. B for 60 years is an exception to this rule. It concerns only the parties and the bishop's successors, and is therefore a private act. Asterisk under this designation full statutes relating to railways and canals, docks and similar undertakings which are generally spoken of as local acts, and also estate acts, acts of naturalization, and statutes relating to individuals, which are thence termed personal acts. Of public acts only were the judges bound formally to take notice judicially and ex officio, without the statute being particularly pleaded or formally set forth by the party claiming an advantage under it. Of private or special acts the judges were not bound to take notice, unless they were formally shown and pleaded, but since 13 and 14 Vic. c. 21 s. 7. The courts are obliged to take judicial notice of all statutes, unless the contrary be expressly therein provided. Statutes also are either declaratory of the common law, or remedial of some defects therein. Declaratory, where the old custom of the kingdom is almost fallen into disuse, or become method of citing very ancient, being the time of Edward IL, is by naming used by the Jews in denominating the year of the king's reign in which books of the Pentateuch, by the Christ statute was made together with the Ian Church in distinguishing their hymns chapter or particular act, according to and divine offices, by the Romanists in its numeral order, as 9 Geo. Roman 2. 4. Describing their papal bulls, and in for all the acts of one session of par short by the whole body of ancient lement taken together make properly civilians and canonists, among whom but one statute, and therefore when to this method of citation generally pre-sessions have been held in 1 year, we veiled, not only with regard to chapters, usually mentioned stat. 1 or 2, thus the but inferior sections also, in imitation Bill of Rights is cited as 1 W, and Emson. 2, of all which we still call some of our old c. 2, signifying that it is the second statute by their initial words, as the chapter or act of the second statute, or statutes of quia impters and that of the laws made in the second session of Sirum spect agatis. But the most usual parliament in the first year of King method of citing them, especially since William and Q.Z. and Mary. The laws of England. Disputable, in which case Parliament has sometimes thought proper, in perpetuum re testimonium, and for avoiding all doubts and difficulties to declare what the common law is and ever has been. Thus the statute of treasons 25 Edua, Roman 3. c. 2, does not make any new species of treasons, but only, for the benefit of the subject, declares and enumerates those several kinds of offences which before were treason at the common law. Remedial statutes are those which are made to supply such defects and abridge such superfluities in the common law as arise either from the general imperfection of all human laws, from change of time and circumstances, from the mistakes and unadvised determinations of unlearned, or even learned, judges, or from any other cause whatsoever. And this being done, either by enlarging the common law where it was too narrow and circumscribed, or by restraining it where it was too lax and luxuriant, has occasioned another subordinate division of remedial acts of Parliament into enlarging and restraining statutes. To instance again in the case of treason, clipping the current coin of the kingdom was an offence not sufficiently guarded against by the common law, Therefore it was thought expedient by Statute 5 Eliz. c. 11, which is now repealed, however, to make it high treason, which it was not at the common law, so that this was an enlarging statute. At common law also spiritual corporations might lease out their estates for any term of years, till prevented by the Statute 13 Eliz, before mentioned. This was therefore a restraining statute. Secondly, the rules to be observed with regard to the construction of statutes are principally these which follow. 1. There are 3 points to be considered in the construction of all remedial statutes: the old law, the mischief, and the remedy. That is, how the common law stood at the making of the act, what the mischief was, for which the common law did not provide, and what remedy the legislature has provided to cure this mischief. And it is the business of the judges so to construe the act as to suppress the mischief and advance the remedy. Let us instance again in the same restraining statute of 13 Eliz. c. 10. By the common law, ecclesiastical corporations might let as long leases as they thought proper. The mischief was that they let long and unreasonable leases, to the impoverishment of their Haydon's case, 3 Kep. 7. Blackwell v. England 8L. NBL. Rep. 541. The laws of England. 63 successors. The remedy applied by the statute was by making void all leases by ecclesiastical bodies for longer terms than 3 lives or 21 years. Now in the construction of this statute it is held that leases, though for a longer term, if made by a bishop, are not void during the bishop's continuance in his see, or if made by a dean and chapter, they are not void during the continuance of the dean. For the act was made for the benefit and protection of the successor. The mischief is therefore sufficiently suppressed by vacating them after the determination of the interest of the grantors, but the leases during their continuance, being not within the misclief, are uot within the remedy. 2. A statute, which treats of things or persons of an inferior rank, cannot by any general words be extended to those of a superior trade, so a statute, treating of deans, prebendaries, parsons, vicars, added others having spiritual promotion, is held not to extend to bishops, though they have spiritual promotion, deans being the highest persons named, and bishops being of a still higher order. 3. Penal statutes must be construed strictly. A rule which, possibly in favorem vici, was formerly carried to an absurd extent. Thus the Statute 1 Edwa. Vi. c. 12, having enacted that those who were convicted of stealing horses should not have the benefit of clergy, the judges conceived that this did not extend to him that should steal but 1 horse, and therefore procured a new act for that purpose in the following year. To come nearer our own times, however, by the Statute 14 Geo. Roman 2. c. 6, stealing sheep or other cattle was made felony without benefit of clergy. But these general words, or other cattle, being looked upon as much too loose to create a capital offense, the act was held to extend to nothing but mere sheep, and therefore, in the next, unless the general words would, modum statutes have generally what otherwise be entirely void. Thus, the is termed an interpretation clause. The Statute of Marlborough, amending the law object of which is to define what is to as to essoins, enumerates essoins and be understood by certain general words counties, hundreds, or in courts baron, used, as that lands shall include or in other courts, and the general hereditaments, such as a right of way. Words other courts were held to X and C 13 and 14 Vic. C. 21 S. 4. 10 to the King's Courts of Record at 2 and 3 Edwa, vi. C. 33. Repealed 7 and 8 Westminster and elsewhere. 2 Inst. 137. Geo. Roman 4. C. 27 S. The laws of England. Session, it was found necessary to make another statute, 15 Geo. Roman 2 C. 34, extending the former to bulls, cows, oxen, steers, bullocks, heifers, calves, and lambs by name. 4. Statutes against frauds are to be liberally and beneficially expounded. This may seem a contradiction to the last rule, most statutes against frauds being in their consequences penal. But this difference is here to be taken. Where the statute acts udge on the offender and inflicts a penalty, it is then to be taken strictly, but when the statute acts upon the offence, by setting aside the fraudulent transaction, here it is to be construed liberally. Upon this footing the statute of 13 is c. 5, which avoids all gifts of goods, and c. made to defraud creditors and others, was held to extend by the general words to a gift made to defraud the crown of a forfeiture. 5. One part of the statute must be so construed by an author, that the whole may, if possible, stand, ut res magis valet quam ferit. As if land be vested in the king and his heirs by act of parliament, saving the right of a, and a has at that time a lease of it for 3 years. Here shall hold it for his term of 3 years, and afterwards it shall go to the king. For this interpretation furnishes matter for every clause of the statute to work and operate upon. But 6. A saving totally repugnant to the body of the act is void. If therefore an act of parliament vests land in the king and his heirs, saving the right of all persons whatsoever, or vests the land of a in the king, saving the right of a, in either of these cases the saving is totally repugnant to the body of the statute, and, if good, would render the statute of no effect or operation, and therefore the saving is void, and the land vests absolutely in the king. P7. Where the common law and a statute differ, the common law gives place to the statute, and an old statute gives place to a new one. And this upon a general principle of universal law that degrees Kepild 7 and 8 Geo. Roman 4. c. 27s. One body of the act is not void, but operates P1 ep. 47. This rule must be taken as a repeal of the preceding enactment, with this limitation, that a distinct N. v. shall see waterworks, fits, clause engrafted upon a preceding enact 195. Meant, though totally repugnant to the England 05. Leg posteriors priors canter areas Aragoni. Consonant to W. Leakley, it was laid down by a law of the 12 tables at Combe, that Kai lud populus postremum jussit, id jus ratu in esto. But this is to be understood only when the latter statute is couched in negative terms, or where its matter is so clearly repugnant, that it necessarily implies a negative. As if a former act says that a juror upon such a trial shall have £20 a year, and a new statute afterwards enacts that he shall have 20 marks, here the latter statute, though it does not express, yet necessarily implies a negative, and virtually repeals the former. For if 20 marks be made a eulification sufficient, the former statute which requires £20 is at an end. But if both acts be merely affinitive, and the substance such that both may stand together, here the latter does not repeal the former, but they shall both have a concurrent efficacy. If by a former law an offence be indictable at the quarter sessions, and the latter law makes the same offence indictable at the assizes, here the jurisdiction of the sessions is not taken away, but both have a concurrent jurisdiction, and the offender may lie prosecuted at either. Unless the new statute subjoins express negative wordles, as that the offence shall be indictable at the assizes, and not else. Gr. 8. Acts of Parliament derogatory from the power of subsequent parliaments bind not. So the statute 11 hen. Roman 7. c. 1, which directs that no person, for assisting a king de facto, shall be attainted of treason by act of parliament or otherwise, is held to be good only as to common prosecutions for high treason, but will not restrain or clog any parliamentary attainder. Because the legislature, being in truth the sovereign power, is always of equal, always of absolute, authority, it acknowledges no superior upon earth which the prior legislature must have been, if its ordinances could bind a subsequent parliament, and upon the 1 Rep. 63. Formerly, if a statute Elizabeth's statute, but these acts of that repealed another was itself repealed King Henry were implicitly and virtually afterwards, the first statute was thereby revived, 4 Inns. 325. See the ease of the revived, without any formal words for 7 Bithop and 12 Rep. 7 and Phillips v. that purpose. So, when the statutes of Hoptude 10b and c. 39, but this rule 2g and 35 hen. Roman 8 declaring the king of KW has been altered by 12 and 13 Vic. to be the supreme head of the Church. C. 21 S. 5. Which enacts that repealed were repealed by 1 and 2 Philip and Mary, statutes shall not be revived by the and this latter statute was afterwards repeal of the act repealing them, unless repealable by 1 is there needed not express words be added reviving such any express words of revival in Queen Regillaful Acts. Vol. 66 of the Laws of England. Same principle Cicero, in his letters to Atticus, treats with a proper contempt these restraining clauses, which endeavored to tie up the hands of succeeding legislatures. When you repeal the law itself, says he, you at the same time repeal the prohibitory clause which guards against such repeal. 9. Lastly, acts of Parliament that are impossible to be performed are of no validity. And if there arise out of them collaterally any absurd consequences, manifestly contradictory to common reason, they are, with regard to those collateral consequences, void. I lay down the rule with these restrictions, though I know it is generally laid down more largely, that acts of Parliament contrary to reason are void. But if the legislature positively enacts a thing to be done which is unreasonable, I know of no power in the ordinary forms of the Constitution that is vested with authority to control it, and the examples usually alleged in support of this sense ctf the rule do none of them prove that where the main object of a statute is unreasonable, the judges are at liberty to reject it, for that were to set the judicial power above that of the legislature, which would be subversive of all government. But where some collateral matter arises out of the general words, and happens to be unreasonable, there the judges are in decency to conclude that this consequence was not foreseen by the legislature, and therefore they are at liberty to expound the statute by equity, and only quod hoc disregard it. Thus, if an act of Parliament gives a man power to try all causes that arise within his manor of Dale, yet if a cause should arise in which he himself is party, the act is construed not to extend to that, because it is unreasonable that any man should determine his own quarrel. But, if we could conceive it possible for the Parliament to enact that he should try as well his own causes as those of other persons, there is no court that has power to defeat the intent of the legislature, when couched in such evident and express words as leave no doubt whether it was the intent of the legislature or no. These are the several grounds of the laws of England, over and above which equi is also frequently called in to assist, to cum lex abrogator, elutif summa bro. Bontum's case, 8 Rep. 115, City of Vater, Giwad non ern argari oportit. London v. Wood 12 Mod. 687. L. 67 Moderate, and to explain them. What equity is and how impossible in its very essence to be reduced to stated rules, has been show/vu in the preceding section. Asterisk we shall have occasion in the 3rd volume of these commentaries to observe how, at an early period of our legal history, it became the function of the Court of Chancery to detect latent frauds and concealments, which the process of the courts of law * was not then adapted to reach, to enforce the execution of such matters of trust and confidence as were considered binding in conscience *, but not cognizable in a court of law, and to give a more specific relief, and one more adapted to the circumstances of the case, than * could be obtained by the generality of the rules of the positive or common law. This was till our own day the peculiar business of our courts of equity, which are now, however, * merged in the High Court of Justice, the several divisions of which must, in all cases of conflict or variance between the rules of equity and the rules of the common law, administer civil justice according to the rules of equity. I say civil justice, for the freedom of our Constitution will not permit that, in criminal cases, a power should be lodged in any judge to construe the law otherwise than according to the letter. This caution, while it admirably protects the public liberty, can never bear hard upon individuals. A man cannot suffer more punishment than the law assigns, but he may suffer less. The laws cannot be restrained by partiality to inflict a penalty beyond what the letter will warrant, and in cases where the letter induces any apparent harsley, the Crown has the desire to pardon the offender or modify his punishment. F2. 68. Section Roman 4. Of the countries subject to the laws of England. The Kingdom of England, over which our municipal laws have jurisdiction, includes not, by the common law, either Wales, Scotland, or Ireland, or any part of the Queen's dominions except the territory of England only. And yet the civil laws and local customs of this territory do now obtain, in part or in all, with more or less restrictions, in these and many other adjacent countries, of which it will be proper first to take a review, before we consider the Kingdom of England itself, the original and proper subject of these laws. Wales continued independent of England, unconquered and uncultivated, in the primitive pastoral state which Caesar and Tacitus ascribed to Britain in general, for many centuries, even from the time of the hostile invasions of the Saxons, when the ancient and Christian inhabitants of the island retired to those natural entrenchments for protection from their pagan visitants. But when these invaders themselves were converted to Christianity and settled into regular and potent governments, this retreat of the ancient Britons grew every day narrower. They were overrun by little and little, gradually driven from one fastness to another, and by repeated losses abridged of their wild independence, till at length in the reign of Edward I, who may justly be styled the conqueror of Wales, the line of their ancient princes was abolished, and the King of England's eldest son became their titular prince, the territory of Wales being then entirely annexed. Sir William Blackstone says, with assumption, to the crown of England, out, however, quoting any authority. But the feudal law was quite unknown that. Very early in our history, we find in Wales, there are no copyholder princes doing homage to the crown tenures and but few if any instances of England. And he speaks of Wales what are termed manorial rights, the being re-annexed by a kind of feudal property being entirely free and allodial. Countries subjecto to laws op England. 69 to the dominion of the Crow/Vian of England. By the Statute of Wales very material alterations were made in divers parts of their laws, so as to reduce them nearer to the English standard, especially in the forms of their judicial proceedings, but they still retained very much of their original polity, particularly their rule of inheritance, viz. That their lands were divided equally among all the issue male, and did not descend to the eldest son alone. By other subsequent statutes their provincial immunities were still farther abridged, but the finishing stroke to their independence was given by the Statute 27 Hen. Roman 8. c. 26, which at the same time gave the utmost advancement to their civil prosperity, by admitting them to a thorough communication of laws with the subjects of England. Thus were this brave people gradually conquered into the enjoyment of true liberty, being insensibly put upon the same footing, and made fellow citizens with their conquerors, a generous method of triumph, which the Republic of Home practiced with great success till she reduced all Italy to her obedience, by admitting the vanquished states to partake of the Roman privileges, why it is enacted by this Statute 27 Hen. Roman vi.1. That the dominion of Wales shall be for ever united to the Kingdom of England. 2. That all Welshmen born shall have the same liberties as other the King's subjects. 3. That lords in Wales shall be heritable according to the English tenures and rules of descent. 4. That the laws of England, and no other, shall be used in Wales. Besides many other regulations of the exchange of this principality. And the Statute of 34 and 35 Hen. Roman 8. c. 26 confirms the same, adds farther regulations, divides the principality into 12 shires, and, in short, reduces it into nearly the same order in which it stands at this day. After this act Wales still differed from England in a few particulars, such as having courts within itself, independent of the process of Westminster Hall till by the Statute 11 Geo. Roman 4, and 1 Will. Roman 4. c. 70. These courts were Barrington's obs. On the ancient stawing calu dollar uia, pritu regidior fidali subtutes. So that wo have no authority for gisha jam in proprilet udiaminium tale theabi? Of a feudal resumption. Ex leader et cum integritu conversa est, et uct the statement of Edward himself, quorunx rigmi anglix hinquem pars coriu the statutum wallis. Portsigos domanixa el unida. Va. 400. The statutum walliis. By the statute of Henry, courts 12 edua. I bears data pod Bothalenum, Baron, 100, and County Artswar or Ruid Laud, in Flintshire, and is to established, and a session was to be the following c. Fifict. Terrawalics come held twice in every year in each county. 70 of the countries subject abolished, and the administration of justice in the principality rendered uniform with that of England. The Kingdom of Scotland, notwithstanding the union of the crowns on the accession of James VI of Scotland to the throne of England, continued an entirely separate and distinct kingdom for above a century more, though a union had been long projected, which was judged to be the more easy to be done, as both kingdoms were anciently under the same government, and still retained a very great resemblance, though far from an identity in their laws. By an Act of Parliament 1 Jac. I. c. 1, it is declared that these two mighty, famous, and ancient kingdoms were formerly one. And Sir Edward Coke observes ** how marvellous a conformity there was, not only in the religion and language of the two nations, but also in their ancient laws, the descent of the crown, their parliaments, their titles of nobility, their officers of state and of justice, their writs, their customs, and even the language of their laws. Upon which account he supposes the common law of each to have been originally the same, especially as their most ancient and authentic book, called Regia Majestorum, and containing the rules of their ancient common law, is extremely similar to that of Glanville, which contains the principles of ours, as it stood in the reign of Henry II. Register, and the many diversities subsisting between the two laws at present may be well enough accounted for from a diversity of practice in two large and uncommunicating jurisdictions, and from the acts of two distinct and independent parliaments, which have in many points altered and abrogated the old common law of both kingdoms. However, Sir Edward Coke, and the politicians of that time, conceived great difficulties in carrying on the projected union. But these were at length overcome, and the great work was by judges appointed by the Crown, which early period adopted in Scotland, with were to be called the Great Sessions, in a few changes and modifications, and which all pleas of real and personal under this new form bears the title of actions were to be held with the same Regia Majestatum, from the initial form of process, and in as ample a manwords of the prologue, which is little nearer as the Court of Common Pleas at more than a transcript from the Prue Westminster. A writ of error therefrom mim of Justinian's Institutes, which lay to the King's Bench. Begins Imperatorium Majestatum. Dr. For inst. 345. Irving's Introd. To the study of the treatise attributed to Glanville Civil Law, p. 83. Is the most ancient book now extant on C. Hallam constit. Hist. having the law of England. It was at a very vol. Roman 3. To the Hawes of England. 71 happily effected in 1707, 5 and 6 Ian, when 25 articles of union were agreed to by the emolument of both nations. The purport of the most considerable being as follows. 1. That on the 1st of May, 1707, and for ever after, the Kingdom of England and Scotland shall be united into one kingdom, by the name of Great Britain. 2. The succession to the monarchy of Great Britain shall be the same as was before settled with regard to that of England. 3. The United Kingdom shall be represented by one Parliament. 4. There shall be a communication of all rights and privileges between the subjects of both kingdoms, except where it is otherwise agreed. 17. The standards of the coin, of weights and of measures shall be reduced to those of England, throughout the United Kingdoms. 11. The laws relating to trade, customs, and the excise shall be the same in Scotland as in England. But all the other laws of Scotland shall remain in force, though alterable by the Parliament of Great Britain, yet with this caution, that laws relating to public jwlicy are alterable at the discretion of the Parliament. Laws relating to private right are not to be altered, but for the evident utility of the people of Scotland. 22. 16J-8 are to be chosen to represent the peerage of Scotland in Parliament, and 45 * members to sit in the House of Commons. 23. The 16 peers of Scotland shall have all privileges of Parliament, and all peers of Scotland shall be peers of Great Britain, and rank next after those of the same degree at the time of the Union, and shall have all privileges of peers except sitting in the House of Lords and voting on the trial of a J-Cager. These are the principal of the 25 Articles of Amiens, C2 and 3 will. Roman 4. C. 6.3. This article has been construed to *. now 60, of whom 32 are prevent the Crown from creating new representative for counties, 7 for Scotch peerages, on the ground that cities and towns, 15 for districts of any such creation would interfere with boroughs, and 2 for the 4 unificeth elective rights of the peers of Scots cities. 2 and 3 will. Roman 4. C. 65, 31 and 32 land which were in S at the time of Vic. C. 48. The Union. 72 OP the countries subject, which are ratified and confirmed by the Statute 5 Ann. C. 8, in which statute there are also 2 Acts of Parliament recited, the one of Scotland, whereby the Church of Scotland, and also the 4 universities of the kingdom, are established for ever, and all succeeding sovereigns are to take an oath inviolably to maintain the same, the other of England, 5 Ann. C. 6, whereby the Acts of Uniformity of 13 Eliz and 13 Car. Roman 2 except as the same had been altered by Parliament at that time, and all other acts then in force for the preservation of the Church of England are declared perpetual, and it is stipulated that every subsequent king and queen shall take an oath inviolably to maintain the same within England, Ireland, Wales, and the town of Berwick upon Tweed. And it is enacted that these 2 acts shall forever be observed as fundamental and essential conditions of the Union. Upon these Articles and Act of Union it is to be observed 1. That the 2 kingdoms are now so inseparably united that nothing can ever disunite them again, except the mutual consent of both, or the successful resistance of either, upon apprehending an infringement of those points, which, when they were separate and independent nations, it was mutually stipulated should be fundamental and essential conditions of the Union. Sir W. Blackstone, in a note to this Visuals, and therefore it is hinted asterisk in passage, observes that it might justly be the text. That such an attempt might doubted wetlier even suckly an infringing danger, though by no means destroy, meant, though a manifest breach of good the Union. Faith, unless done upon the most pressing there can now be no doubt whatever necessity, would of itself dissolve that an Act of Parliament to repeal or Union, for the bare idea of a state, with alter the Act of Uniformity in England, out a power somewhere vested to alter or to establish episcopacy in Scotland, every part of its laws is the height of wood. B. The binding, that, not with political absurdity. And he argues, standing such an act, the Union would that in such an incorporate Union, as was continue unbroken, and that each of created by the Act of Union, and asterisk which is these measures might be safely and distinct from a federate alliance, where honorably pursued, if respectively agree such an infringement would certainly able to the sentiments of the English rescind the compact, the 2 contracting church, or the kirk in Scotland. But its states are totally annihilated, without would be neither prudent, nor perhaps any power of a revival, and a third consistent with good faith to venture uprisers from their conjunction, in which on either of those steps by a spontaneous all the rights of sovereignty, and particular exertion of the inherent powers of parliament that of legislation, must of necessment, or at the instance of mere individuality reside. See Warburton's Alliance, Owls. Poor so sacred are the laws above 195. But the wanton or imprudent is referred to as deemed, that in all the reaction of this right would the learned Gency Acts of 1751, 1755, 1811, 1830, and commentator adds, probably raise a very 1840. The regents are expressly disabled alarming ferment in the minds of indifferent assenting to the repeal or alteration. Laws of England. 73.2. That whatever else may be deemed fundamental and essential conditions. The preservation of the 2 churches of England and Scotland, in the same state that they were in at the time of the Union, and the maintenance of the Acts of Uniformity which establish our common prayer, are expressly declared so to be. 3. That therefore any alteration in the constitution of either of those churches, or in the liturgy of the Church of England, unless with the consent of the respective churches, collectively or representatively given, would be an infringement of these fundamental and essential conditions and greatly endanger the Union. 4. That the municipal laws of Scotland are ordained to be still observed in that part of the island, unless altered by Parliament, and they still, with regard to the particulars unaltered, continue in full force. Wherefore the municipal or common laws of England are as such of no force or validity in Scotland, and consequently, in the ensuing commentaries very few occasions will present themselves for mentioning, any farther than sometimes by way of illustration, the municipal laws of that part of the United Kingdoms. The town of Berwick-on-Tweed was originally part of the Kingdom of Scotland, and, as such, was for a time reduced by King Edward I into the JWS cession of the Crown of England. And during such its subjection, it received from that prince a charter which, after its subsequent cession by Edward Balliol to be for ever united to the Crown and realm of England, was confirmed by King Edward Roman III, with some additions, particularly that it should be governed by the laws and usages which it enjoyed during the time of King Alexander, that is, before its reduction by Edward I. Its constitution was new-modelled and put upon an English footing by a charter of King James I, and all its liberties, franchises, and customs were confirmed in Parliament by the Statutes 22 Edw. Roman IV, c. 8 and 2 Jack, IC. 28. Though therefore it had some local peculiarities, derived from the ancient laws of Scotland, yet it is clearly part of the realm of England, being represented by burgesses in the House of Commons and bound by all acts of the British Parliament, whether specially named or otherwise, and therefore of either these, or the Act of Settlement, by any public general statute, a clause CX8T, p. 79, no, is generally inserted for that purpose, when Scotland is not to be affected. Rex v. Cowell 2 Burr, 834. 74 of the countries subject it was, perhaps superfluously, declared by Statute 20 Geo. Roman 2. c. 42. That where England only is mentioned in any Act of Parliament, the same notwithstanding has and shall be deemed to comprehend the dominion of Wales and town of Berwick-upon-Tweed. And though certain of the writs of the courts of Westminster do not usually run into Berwick, yet it has been solemnly adjudged that all prerogative writs, as those of mandamus, prohibition, habeas corpus, certiorari, and c. may issue to Berwick, as well as to every other of the dominions of the Crown of England, and that indictments and other local matters arising in the town of Berwick may be tried by a jury of the county of Northumberland. And as to Ireland, that asterisk was, until the union with Great Britain in 1801, a distinct kingdom. It was entitled the Dominion or Lordship of Ireland, the royal style being J. Dominus Hibernias, Lord of Ireland, till the 33rd year of King Henry VIII, when the title of King was conferred by an Act of the Irish Legislature, which is recognized by Act of Parliament 35 Hen. Roman 8. c. 3. Scotland and England are now one and the same kingdom, yet differ in their municipal laws. England and Ireland, on the other hand, though so long distinct kingdoms, yet in general agree in their laws. For after the conquest of Ireland by King Henry II, the laws of England were received and sworn to by the Irish nation, assembled at the Council of Lismore. P. At the time of this conquest the Irish were governed by what they called the Brehon law, so styled from the Irish name of judges. Avo were denominated Brehons. But King John, in the 12th year of his reign, went into Ireland, and carried over with him many able sages of the law, and there, by his letters patent, is said to have ordained and established that Ireland should be governed by the laws of England, which letters patent Sir Edward Coke apprehends to have been there confirmed in Parliament. But to this ordinance many of the Irish were averse to conform, and still stuck to their Brehon law, so that both Crow, Det. 543, 2 Rall, Aber, 292, 33 Hen. Roman 8. c. 1. Stat. 11 Geo. IC. 4. 2 Burr. 834, 855. Prin. On Foreign's. 249. Mayor of Berwick v. Shanks, 3 Bing. Foreign's. 358. Edom. Spencer's State of 459, 5 and 6 Will. Roman 4. c. 76 Section 109. Ireland p. 113, edit. Hughes. Stat. Hymiak 14 hen. Roman 3. 1 inst. 141. Henry III and Edward I were obliged to renew the injunction, and at length in a parliament holden at Kilkenny, 40 Edwa. Roman 3 under Lionel Duke of Clarence, the then Lieutenant of Ireland, the Brehon law was formally abolished, it being unanimously declared to be indeed no law, but a lewd custom crept in of later times. And yet, even in the reign of Queen Elizabeth, the wild natives still kept and preserved their Brehon law, which is described to have been a rule of right unwritten, but delivered by tradition fixed and one to another, in which often times there appeared great show of equity in determining that right between party and party, but in many things repugnant quite both to God's laws and man's. The latter part of this character is alone ascribed to it by the laws before cited of Edward I and his grandson. But as Ireland was a distinct dominion, and had parliaments of its own, it is to be observed that though the immemorial customs or common law of England were made the rule of justice in Ireland also, yet no acts of the English Parliament, since the 12th of King John, extended into that kingdom. And this is particularly expressed, and the reason given in the Yearbook I. A tax granted by the Parliament of England shall not bind those of Ireland, because they are not summoned to our Parliament, **. And again, Ireland hath a parliament of its own, and maketh and altereth laws, and our statutes do not bind them, because they do not send ill knights to our parliament. But their persons are the king's subjects, like as the inhabitants of Calais, Gascoigne, and Guienne, while they continued under the king's subjection. *A. R. 30. 1 Rim. Fode. 442. Extend you care to any of its subordinate. A. R. 5. Free Prin. Rec. 1218. Dominions, and mentions them expressly. Hound D.M. Spencer, Ibid. By name or includes them under general. Sir William Blackstone Hero adds words, there can be no doubt, but then, unless it were specially named whole, or in there bound by its laws. Urlex OK, eluded under general words such as 1 hen. Roman 7. Free. Calvin * case 7 rep. 22. Within any of the king's dominions. BL. Com. P. 101. Admitting the parent shortly afterwards thus maintains Liement of England to have been his proposition. The general run of sovereign legislature, there is no diff clause, enacted by the superior state, are culti in the learned commentator's view supposed to be calculated for its own as to the dependency of Ireland. But internal government, and do not extend the yearbooks, seem to demonstrate that to its distant dependent countries, which, the acts of the Parliament of England bearing no part in the legislature, could not bind Ireland, and this was not therefore in its ordinary and daily evidently the opinion held by Sir Contemplation. But when the sovereign Edward Coke ** legislative power sees it necessary to 20 hen. Vi. 8. Too rich. Roman 3. 12. The countries subject the original method of passing statutes in Ireland was nearly the same as in England, the chief governor holding parliaments at his pleasure, which enacted such laws as they thought proper. But an ill use being made of this liberty, particularly by Lord Gormanstown, deputy lieutenant in the reign of Edward Roman 4. A set of statutes was there enacted in the 10 hen. Yea, Sir Edward Poynings being then Lord Deputy, whence they are called Poynings. Laws, one of which in order to restrain the power as well of the deputy as of the Irish Parliament, provided, 1. That before any Parliament was summoned or holden, the chief governor and council of Ireland should certify to the king under the great seal of Ireland the considerations and causes thereof, and the articles of the acts proposed to be passed therein. 2. That after the king, in his council of England, should have considered, approved, or altered the said acts or any of them, and certified them back under the great seal of England, and should have given license to summon and hold a parliament, then the same should be summoned and held, and therein the said acts so certified, and no other should be proposed, received, or rejected. But as this precluded any law from being proposed, but such as were preconceived before the Parliament was in being, which occasioned many inconveniences and made frequent dissolutions necessary, it was provided by the Statute 3 and 4 Philip and Mary, that any new propositions might be certified to England in the usual forms, then after the summons and during the session of Parliament. By this means, however, there was nothing left to the Parliament in Ireland, but a bare negative or power of rejecting, not of proposing or altering any law. The Irish nation, being thus excluded from the benefit of the English statutes, were deprived of many good and profitable laws made for the improvement of the common law, and, the measures of justice in both kingdoms becoming thence no longer uniform, it was therefore enacted by another of Poyning's laws cap. 22. That all acts of Parliament, before made in England, should be of force within the realm of Ireland. By the same rule, that no laws made in England, between King John's time and Poyning's law, were then binding in Ireland, it follows that Irish Stat. 11 is Stat. 3c. A. Cap. 4. Expounded by the Statute 3 and Irish Stat. 10 hen. Roman 7. C. 23. 4 ph. And m. C. 4. Laws of England. 77 No acts of the English Parliament made since the 10 hen. Roman 7. Con will bind the people of Ireland. Asterisk it was accordingly thought necessary asterisk to declare how that matter really stood. And therefore by Stat. 6 Dio. I.C. 5 it declared that the Kingdom of Ireland ought to be subordinate to, and dependent upon, the imperial crown of Great Britain, as being inseparably united thereto, and that the King's Majesty, with the consent of the Lords and Commons of Great Britain and Parliament, has power to make laws to bind the people of Ireland. Asterisk this statute was, however, repealed by the 22 Geo. Roman 3. C. 58, and by an act of the following session, 23 Geo. Roman 3. C. 28, it was declared that in all cases whatever, the people of Ireland should be bound only by laws enacted by His Majesty and the Parliament of the Kingdom, the effect of which evidently was to make the legislature of Ireland as sovereign as the legislature of Great Britain had by the Statute of Geo. I. attempted to make itself. In the meantime, however, by an act of the Irish Parliament, 21 and 22 Geo. Roman 3. C. 48, it had been enacted that all statutes then made in England or Great Britain should be accepted, used, and executed in Ireland. Thus we see how extensively the laws of Ireland communicate with those of England, and indeed such communication is highly necessary, as the ultimate resort from the courts of justice in Ireland, was and now is to those in England. A writ of error lay formerly from the King's Bench in Ireland to the King's Bench in England, and an appeal from the Chancery in Ireland lay immediately to the House of Lords here, it being expressly declared, by the Statute 6 Geo. I.C. 5, that the peers of Ireland have no jurisdiction to affirm or reverse any judgments or decrees whatsoever, until the above-mentioned Statute 23 Geo. Roman 3. C. 28, enacted, that no appeal or writ of error should be brought from any court in Ireland to any court in England. The Act of. According to B.L. Tixton, from the called Diversite de Curt C. Bankla, state of dependence being almost for Roy, gotten and ready to be disputed by the Sir William Blackstone, certainly Irish nation, considered the Statute 6 Geo. I.C. 5 above. This was law in the time of Hen, referred to binding on Ireland. Roman 8 as appears by the ancient book of the country's subject union, however, restored the right of appeal to the House of Lords in both cases. The legislative union of Great Britain and Ireland was effected in the /5 Acts J. Dotates Rio, with what difficulties and by what means need not here be mentioned. The purport of the 8 articles of this union registered are as follows. 1. The kingdoms of Great Britain and Ireland are united into one kingdom, by the name of the United Kingdom of Great Britain and Ireland. 2. The succession to the crown of the United Kingdom is settled in the same manner as the succession to the crown of Great Britain and Ireland stood before limited. 3. The United Kingdom is to be represented in one and the same Parliament styled the Parliament of the United Kingdom of Great Britain and Ireland. 4. 4 Lords Spiritual of Ireland by rotation of sessions * and 28 Lords Temporal of Ireland, elected for life by the peers of Ireland, are to sit in the House of Lords. A peer of Ireland not elected to sit in the House of Lords is to be capable of serving in the House of Commons, but not for an Irish constituency, and no creation of an Irish peerage is to take place, unless 3 Irish peerages shall have become extinct until the number of Irish peers is reduced to 100, but the peerage of Ireland is to be kept up to that number over and above the number of such of the said peers as shall be entitled to a hereditary seat in the House of Lords. 100 commoners, 2 for each county, 2 for each of the cities of Dublin and Cork, 1 for Trinity College, and 1 for each of the 31 most considerable cities and boroughs, are to sit and vote in the House of Commons on the part of Ireland. 5. The churches of England and Ireland, as by law established, are united into one Protestant Episcopal Church to be called the United Church of England and Ireland, and the doctrine. See Diary and Correspondence of now 103, 30 Lord Cornwallis. London, 1859. 7 for cities and boroughs and 2 British Statute, 39 and 40 Geo. Roman 3. For the University. 2 and 3 Will. Roman 4. C. 67, Irish Statute, 40 Geo. Roman 3. C. 38. 88 S. 9, 31 and 32 Vic. C. 49. Asterisk by the Statute 32 and 33 Vict. C. 42. The legislature conferred this date. 13. No archbishop or bishop of designation on the United Church. In no Church of Ireland is to be qualified or to official act, that I am aware of, has the act as such in the House of Peers. Church of England ever, so described * Fermoy Peerage, session with May 8 and Drive to 5 to 56. Itself. The laws of England. 79 Worship, discipline, and government of the United Church are to be and remain in full force and forever as the same are by law established in England. This union came to an end on the 1st of January, 1871. 6. The subjects of Great Britain and Ireland are to be entitled to the same rights and privileges in trade and navigation, and also in treaties with foreign powers. 8. All the laws and courts of each kingdom are to remain as then established, subject to alterations by the United Parliament, but all writs of error and appeals are to be decided by the House of Lords of the United Kingdom, except appeals from the Court of Admiralty in Ireland, which are to be decided by a court of delegates appointed by the Court of Chancery in Ireland. All existing laws contrary to these articles are repealed. With regard to the other adjacent islands, which are subject to the Crown of Great Britain, some of them, as the Isle of Wight, of Portland, of Thanet, and C. are comprised within some neighboring county, and are therefore to be looked upon as annexed to the mother island, and part of the Kingdom of England. But there are others which require a more particular consideration. And first, the Isle of Man is a distinct territory from England, and is not governed by our laws, neither does any Act of Parliament extend to it, unless it be particularly named therein, and then an Act of Parliament is binding there. It was formerly a subordinate feudatory kingdom, subject to the kings of Norway, then to King John and Henry Roman III of England, afterwards to the kings of Scotland, and then again to the Crown of England. And at length we find King Henry Roman IV claiming the island by right of conquest, and disposing of it to the Earl of Northumberland, upon whose attainder it was granted, by the name of the Lordship of Man, to Sir John de Stanley by letters patent 7 Hen. IV. And his lineal descendants it continued for 8 generations till the death of Fernando Earl of Derby, A.D. 1594, when a controversy arose concerning the inheritance thereof, between his daughters and William his surviving brother, upon J. 32 and 33 Vict. 42. And although dread of a devolution thereof seems to the continuance and preservation of it have been entertained for one moment. United Church, so established in 1800, for inst. 284, 2n. 116, c16, and was to be deemed an essential, and 17 vict. c. 107, 8.346. Fundamental part of the Union, no. Selden tit. Hon. 1, 3. Country subject which, and a doubt that was started concerning the validity of the original patent trade the island was seized into the Queen's hands, and afterwards various grants were made of it by King James I, all which being expired or surrendered, it was granted afresh in 7 Jack. I. To William Earl of Derby, and the heirs male of his body, with remainder to his heirs general, which grant was the next year confirmed by Act of Parliament with a restraint of the power of alienation by the said Earl and his issue male. On the death of James Earl of Derby, A.D. 1735, the male line of Earl William failing, the Duke of Atholl succeeded to the island as heir general by a female branch. In the meantime, though the title of king had long been disused, the Earls of Derby, as lords of man, had maintained a sort of royal authority therein, by assenting or dissenting to laws and exercising an appellate jurisdiction. Yet though no ordinary process from the courts of Westminster was of any authority in man, an appeal lay from a decree of the Lord of the Island to the King of Great Britain in council. But the distinct jurisdiction of this little subordinate royalty being found inconvenient for the purposes of public justice and for the revenue, it affording a commodious asylum for debtors, outlaws, and smugglers, authority was given to the Treasury by Statute 12 Geo. IC. 28, to purchase the interest of the then proprietors for the use of the Crown, which purchase was at length completed in the year 1765, and confirmed by Parliament. The whole island and all its dependencies, by subsequent statutes, became inalienably vested in the Crown, and subject to the regulations of the British Excise and Customs. The writ of habeas corpus has been made to run therein by express enactment *, although this and all other prerogative writs were issuable at common law to all the dominions of the Crown. By other statutes *, the island was subjected to the jurisdiction of the Court of Chancery, whose authority is now vested in the High Court of Justice. The islands of Jersey, Guernsey, Sark, Alderney, and their appendages were parcel of the Duchy of Normandy, and were united to the Crown of England by the first princes of the Norman. Camden, Eliz. A.D. 1594. 56 Dio. Roman 3. He. 100. 1 P. WMS. 329. Bexfee. Cowell, Tuber. 85 3. 5 Dio. Roman 3. CC. 26 and 39. 2 and 3 Will. Roman 4. C. 33. 4 and 5 Will. P 43 Geo. Roman 3. C. 123 6 Geo. Roman 4. C. Roman 4. C 82. 34. The Judicature Act, 1873. The lie AWS up England. 81 line. They are governed by their own laws, which are for the most part the ducal customs of Normandy, being collected in an ancient book of very great authority entitled Le Grand Costumier. The ordinary writ, or process of the courts of Westminster, is there of no force, although a royal commission is, but the writ of habeas corpus, and the other prerogative writs run into these islands. They are not bound by common acts of our parliaments, unless particularly named. All causes are originally determined by their own officers, the bailiffs and jurats of the islands, but an appeal lies from them to the sovereign and council, in the last resort. Besides these adjacent islands, our more distant colonies and dependencies are also in some respects subject to the English laws. Colonies, or plantations as they were formerly termed, in distant countries are either such where the lands are claimed by right of occupancy only, by finding them desert and uncultivated, and peopling them from the mother country, or where, when already cultivated, they have been either gained by conquest or ceded to us by treaties. and both these rights are founded upon the law of nature, or at least upon that of nations. But there is a difference between these two species of colonies, with respect to the laws by which they are bound. For it has been held that if an uninhabited country be discovered and planted by English subjects, all the English laws then in being, which are the birthright of every subject *, are immediately there in force. But this must be understood with very many and very great restrictions. Such colonists carry with them only so much of the English law as is applicable to their own situation and the condition of an infant colony, such, for instance, as the general rules of inheritance and of protection from personal injuries. The artificial refinements and distinctions incident to the property of a great and commercial people, the laws of police and revenue, such especially as are enforced by penalties, the mode of maintenance for the established clergy, the jurisdiction of spiritual courts, and a multitude of other provisions, are neither necessary nor convenient for them, and therefore are not in force. What shall be admitted and what rejected, at what times and under what restrictions, must in case of dispute be decided in the first. Carus Wilson 8 Case 7Q. B. 984. 2p. WMS. 75. Camp UV. HAU. 4 ins. 286. CKWP. 206. Sal. 411, 666. Vol. 82 of the countries subject instance by their own provincial judicature, subject to the revision and control of the sovereign and council. But such colonists are entitled as part of their birthright, when new laws or forms of government come to be framed for their adopted country, to be represented in their own legislature, the election of representatives being, as Lord Chief Justice Holt expresses it, unoriginal right vested in and inseparable from the freehold, neither to be given nor taken away by the Crown or Parliament of the parent state. The Crown may therefore constitute a legislature containing this representative element. But it cannot take away, or even modify, this inherent right to self-government, and if it is desired to establish any different form of legislature, this must be done by the general superintending power of the mother country. In conquered or ceded countries, again, that have already laws of their own, the sovereign may indeed alter and change those laws, but till he does actually change them, the ancient laws of the country remain, unless such as are against the law of God, as in the case of an infidel country da. Thus the laws of Spain, Holland, and France are still wholly or partially in force in the colonies which have been acquired from those powers. The French Code de la Martinique, for instance, in St. Lucia, and part of the feudal laws of France, affecting land in Lower Canada, 4 of the 5 branches of the Code Napoleon in the Mauritius, the Spanish Capitulation de las Indias in Trinidad, the Roman Dutch law of the 7 United Provinces in British Guiana, the Cape of Good Hope, and Ceylon, the old Sicilian laws in Malta, and the Hindu and Mohammedan laws in British Hindustan. Nor are there wanting instances in which the laws and usages of ceded and conquered territories, though inconsistent with, and even repugnant to those of the parent state, have been permitted to survive their annexation to the British Empire. Thus, in the celebrated case of General Picton, the question was much argued though not finally decided, whether obtaining evidence by torture was legal in Trinidad. Polygamy has been tolerated in Ceylon, the burning of widows in India, and slavery in our American dependencies. To recognize, remodel, or altogether supersede the laws of a conquered country is thus a part of the prerogative of the Crown, and the same powers belong to the sovereign with respect to ceded Y7 Rep. 17. Calvin's case, show. Perry. To the laws of England. 83 territories, unless his right has been restricted by the Articles of Cession, which by the law of nations are sacred and inviolable, until altered by the legislature of the territory itself. When once, however, the Crown has established or recognized a legislature in any dependency, its own power to tax and to legislate altogether ceases. In some instances these powers of legislation are restricted. In all cases the acts or ordinances of a dependency are subject to the allowance or disallowance of the Crown. Bearing in mind these distinctions, our dependencies may now be divided, as regards their existing political institutions, into 3 causes. Asterisk I. Those possessing representative institutions under grant from the Crown, usually by a commission, sometimes by order in council or charter. Asterisk Roman II. Those obtained by conquest for which the Crown retains the power of legislation, and which are popularly termed Crown colonies. For although in most of them the ordinary functions of legislation are vested in councils nominated by the sovereign, the Crown retains in itself the concurrent and paramount power of legislation. Asterisk Roman III. Those dependencies of which the Constitution has been established by statute, the aid of Parliament having been required, in some cases to give representative institutions where former acts or other obstacles stood in the way, in other cases to establish Crown or nominated councils. The constitutions of all these dependencies, which possess representative institutions, whether established by the Crown or by Parliament, have generally been framed on the model of that of the parent state, the Governor, Legislative Council, and House. Mills. Constitutions of the British Trinidad and St. Lucia, and possibly dependencies. London, Murray, 1856. British Guiana. To this class belong Jamaica and, of the former class are Canada, all the older or British West Indian Newfoundland, the Australian colonies, all the North American ULO generally, and New Zealand, of the NIs except Canada and Newfoundland, latter Western Australia, the settlements the Cape of Good Hope, Malta, and on the west coast of Africa, St. Helena, Natal, Hong Kong, the Falkland Islands, and Gibraltar, Heligoland, Labuan, the territories formerly of the East India Ceylon, Mauritius, British Kaffraria Company. Of the countries subject of assembly represent respectively, in theory at least, the sovereign, lords, and commons of the imperial parliament, and usually possess collectively the same powers of legislating for the colony as the imperial parliament for the mother country. The territories which for 100 years were governed by the East India Company, the extent and importance of which may seem to require more particular notice, can hardly be said in principle to stand on a different footing from any other dependency. They are now under the direct sovereignty of the Crown, whose authority is exercised by one of the Secretaries of State, assisted by the Council of India. The supreme local administration is vested in a Governor-General and Council, the latter partly nominated and partly official, who possess the ordinary legislative functions and exercise a general authority over the subordinate governments of British India. The Governor-General is, however, invested with the supreme executive authority, which may be exercised with or without the concurrence of his council. All these our dependencies have courts of justice of their own law, from whose decision an appeal lies to the sovereign and council here in England. These are the several parts of the dominions of the Crown of Great Britain, in which the municipal laws of England are not of force or authority, merely as the municipal laws of England. Most of them have probably copied the spirit of their own law from this origin, but then it receives its obligation and authoritative force from being the law of the country. We come now to consider the Kingdom of England in particular, the direct and immediate subject of those laws concerning which we are to treat in the ensuing commentaries. And this comprehends not only Wales and Berwick, of which enough has been already said, but also part of the sea, for the main or high seas are part of the realm of England, and thereon our courts have jurisdiction, as will be shown hereafter. 21 and 22 Vict. C. 106. 24 and 25 Vic. Admiralty have divisum imperium and c. 95, 32 and 33 Vict. C. 97. Alternate jurisdiction. One upon the main or high seas are not sub-water, when it is full sea, and the other ject to the common law. Co. Lit. 260. Upon land, when it is an ebb. Finch. L. This main sea begins at low water mark. 78. As to the extent of the shore but between the high water mark and which of common right belongs to the low water mark, where the sea ebbs Crown, CAG, v. Chambers, 4 dejects and flows, the common law and the Mac. And Gore. 206. The laws of England. 85. The territory of England is liable to 2 divisions. The one ecclesiastical, the other civil. 1. The ecclesiastical division is, primarily, into two provinces, those of Canterbury and York. A province is the circuit of an archbishop's jurisdiction. Each province contains divers dioceses, or sees of suffragan bishops, whereof Canterbury includes 21, and York 6. Every diocese is divided into archdeaconries, each archdeaconry into rural deaneries, which are the circuit of the archdeacons and rural deans' jurisdiction, of whom hereafter, and every deanery is divided into parishes. A parish is that circuit of ground which is committed to the charge of one parson, or vicar, or other minister having tier of souls therein. How ancient the division of parishes is, may at present be difficult to ascertain, for it seems to be agreed on all hands that in the early ages of Christianity in this island parishes were unknown, or at least signified the same thing that a diocese does now. There was then no appropriation of ecclesiastical dues to any particular church, but every man was at liberty to contribute his tithes to whatever priest or church he pleased, provided only that he did it to some, or if he made no special appointment or appropriation thereof, they were paid into the hands of the bishop, whose duty it was to distribute them among the clergy, and for other pious purposes, according to his own discretion. Camden says, England was divided into parishes by Archbishop Honorius about the year 630. Sir Henry Hobart lays it down that parishes were first erected by the Council of Lateran, which was held AD 1179, each widely differing from the other, and both of them perhaps from the truth, which will probably be found in the medium between the two extremes. For Selden has clearly shown that the clergy lived in common without any division of parishes, long after the time mentioned by Camden. And it appears from the Saxon laws that parishes were in being long before the date of that Council of Lateran to which they are ascribed by Hobart. We find the distinction of parishes, nay even of mother churches, including St. Albans 38 and 39 Vict. In his Britannia c. 34. Hob. 29 g. Seld. Of Tightly. 9-4. 2 ins. G4G, Hob. J of Tithes C. C. Kembla Saxons 296. In England. Of the country's subject so early as in the laws of King Edgar, about the year 970. Before that time the consecration of tithes was in general arbitrary. That is, every man paid his own to what church or parish he pleased. But this being liable to be attended with either fraud, or at least caprice, in the persons paying, and with either jealousies or mean compliances in such as were competitors for receiving them, it was now ordered by the law of King Edgar that Denter omnes decims primaris ecclesiam ad quam parochia per tinit. However, if any thane, or great lord, had a church within his own demesnes distinct from the mother church, in the nature of a private chapel, then, provided such church had a cemetery or consecrated place of burial belonging to it, he might allot 1/3 of his tithes for the maintenance of the officiating minister. But if it had no cemetery, the thane must himself have maintained his chaplain by some other means, for in such case all his tithes were ordained to be paid to the praenary ecclesiam, or mother church. This proves that the kingdom was then generally divided into parishes, which division happened probably not all at once, but by degrees. For it seems pretty clear and certain that the boundaries of parishes were originally ascertained by those of a manor or manors, since it very seldom happens that a manor extends itself over more parishes than one, though there are often many manors in one parish. The lords, as Christianity spread itself, began to build churches upon their own demesnes, or wastes, to accommodate their tenants in one or two adjoining lordships, and, in order to have divine service regularly performed therein, obliged all their tenants to appropriate their tithes to the maintenance of the one officiating minister, instead of leaving them at liberty to distribute them among the clergy of the diocese in general. And this tract of land, the tithes whereof were so appropriated, formed a distinct parish, which will well enough account for the frequent intermixture of parishes one with another. For if a lord had a parcel of land detached from the main of his estate, but not sufficient to form a parish of itself, it was natural for him to endow his newly erected church with the tithes of those disjointed lands, especially if no church was then built in any lordship adjoining to those outlying parcels. Thus parishes were gradually formed, and parish churches endowed with the tithes that arose within the circuit assigned. Cell. Of tithe. C. 1. Seld. Of tithe. C. 2. LL. Canet. To the laws op England. 87. But some lands, either because they belonged to religious houses, or were the property of the crown trade, or because they were in the hands of irreligious and careless owners, or were situate in forest and desert places, or for other now unsearchable reasons, were never united to any parish, and therefore continue to this day extraparochial. And their tithes are by immemorial custom payable to the crown instead of the bishop, in trust and confidence that the sovereign will distribute them for the general good of the church. Asterisk. And thus much for the ecclesiastical division of this kingdom, which has for some purposes, however, been adopted as a civil division, particularly in the series of statutes called the Poor Laws. 2. The civil division of the territory of England is into counties, of those counties into hundreds, of those hundreds into tithings or towns. Which division, as it now stands, is said to owe its origin to King Alfred : who, to prevent the rapines and disorders which formerly prevailed in the realm, is reputed to have instituted tithings, so called from the Saxon, because 10 freeholders with their families comst one. These all dwelt together, and were sureties or free pledges to the king for the good behavior of each other, and if any offence was committed in their district, they were bound to have the offender forthcoming. And therefore anciently no man was suffered to abide in England above 40 days, unless he were enrolled in some tithing or decennary. One of the principal inhabitants of the tithing was annually appointed to preside over the rest, being called the tithiugman, the Hebrew words which speak their own etymology, and in some counties the borsholder or borough-sealder, being supposed the discreetest man in the borough, town, or tithing. Tithings, towns, or vills are of the same signification in law. Couple. Apps. 1851, B.I. P. Roman 22, Landy, when improved and drained, our provision has, however, been made by the statute 17 Geo. Roman 2, C. 37, to be for the relief of their poor, and for the assess to all parochial rates in the celebration of marriages in such of them parish next adjoining, as have a church or chapel within there. But see Ulam mid, ages, vol. Roman 2. Limits. 20 vict, c. 19, 23 and 24 vict. Ch. 8. Kemble's Saxons in England. 0. 24. Flet. 1. 47. Laws of Edward II Ince. G. 47. 2 Rep. 44. Grow. Eliz. C. John Fesser C. 20. 512. Extraparochial wastes and marsh are said to have had, each of them, originally a church and celebration of divine service, sacraments, and burials. Though that seems to be rather an ecclesiastical than a civil distinction. The word to 7I or vil is indeed, by the alteration of times and language, now become a generic term, comprehending under it the several species of cities, boroughs, and common towns. A city is described to be a town incorporated, which is or has been the see of a bishop. And though the bishopric be dissolved, as at Westminster, yet still it remains a city/a borough is primarily a town, either corporate or not, that sends burgesses to Parliament. But there are many boroughs or towns incorporated, which have ceased to do so, and others which have never enjoyed that privilege. Other towns there are, which are neither cities nor boroughs, some of which have the privileges of markets and others not, but both are equally towns in law. To several of these towns there are small appendages belonging, called hamlets, which are taken notice of in the statute of Exeter *, which makes frequent mention of entire vills, demi-vills, and hamlets. Entire vills Sir Henry Spelman * conjectures to have consisted of 10 freemen or frank pledges, demi-vills of 5, and hamlets of less than 5. These little collections of houses are sometimes under the same administration as the town itself, sometimes governed by separate officers, in which last case they are, to some purposes in law, looked upon as distinct townships. These towns, as was before hinted, contained originally each but one parish and one tithing, though many of them now, by the increase of inhabitants, are divided into several parishes and tithings, and, sometimes where there is but one parish there are 2 or more villes or tithings. As 10 families of freeholders made up a town or tithing, so 10 tithings composed a superior division called 100, as consisting of 10 times 10 families. The 100 is governed by it. Co. Lit. 109. At the council, as in Domesday, the restoration of the assembled in 1072, to settle the precedents, bishopric of Ripon did not elevate that between the archbishops of Canterbury town into a city, nor had the creation of and York. It was ordered that all bishops, the bishopric of Manchester, any such see, should be transferred from towns to effect. Manchester is a city, by order cities, so that there was no necessary of the Queen and Council, connection between a see and a city. 14 Edwa. I. And indeed places in which no episcopal Gloss. 274. Jurisdiction ever existed are called cities. The laws op England. 89 High Constable or Bailiff, and formerly there was regularly held in it the 100 Court for the trial of causes, though now fallen into disuse. In some of the more northern counties these hundreds are called wapentakes. The subdivisions of hundreds into tithings seems to be more peculiarly the invention of Alfred. The institution of hundreds themselves he rather introduced than invented, for they seem to have obtained in Denmark. And we find that in France a regulation of this sort was made about 200 years before, set on foot by Clotharius and Childebert, with a view of obliging each district to answer for the robberies committed in its own division. These divisions were, in that country, as well military as civil, and each contained 100 freemen, who were subject to an officer called the Senienarius, a number of which Ciitenarii were themselves subject to a superior officer called the Count or Comes. And indeed something like this institution of hundreds may be traced back as far as the ancient Germans, from whom were derived both the Franks who became masters of Gaul, and the Saxons who settled in England, for both the thing and the name, as a territorial assemblage of persons, from which afterwards the territory itself might probably receive its denomination, were well known to that warlike people. An indefinite number of these hundreds make up a county or shire. Shire is a Saxon word signifying a division, but a county, comitatum, is plainly derived from comes, the count of the Franks, that is, the eadle, or alderman, as the Saxons called him, of the shire, to whom the government of it was entrusted. This he usually exercised by his deputy, still called in Latin vicecomes and in English the sheriff shrieve, or shireve, signifying the officer of the shire, upon whom, by process of time, the civil administration of it is now totally devolved. In some counties there is an intermediate division between the shire and the hundreds, as Lathes in Kent, and Rapes in Sussex, each of them containing about 2 lyri or 4 hundreds apiece. These had formerly their laidreeves and rapereeves, acting in subordination to the shire reeve. Where counties divided into 3 of these intermediate jurisdictions, they are called trithings, which Seld, in Fordesk, c. 24. Tacit de More, Germ. 6. Seld, tit, of honor, 2, 5, s. ll. Edwa, c. 34. Montesque, sp. l. 90 of the countries subject were anciently governed by a trithing reeve. These trithings still subsist in the large county of York, where by an easy corruption they are denominated ridings, the North, the East, and the West Riding. The number of counties in England and Wales have been different at different times. At present they are 40 in England, and 12 in Wales. 3 of these counties, Chester, Durham, and Lancaster, are called counties palatine. The 2 former are such by prescription, or immemorial custom, or at least as old as the Norman conquest. The latter was created by King Edward Roman III, in favor of Henry Plantagenet, first Earl and then Duke of Lancaster, whose heiress being married to John of Gaunt the king's son. The franchise was greatly enlarged and confirmed in Parliament, to honor John of Gaunt himself, whom, on the death of his father-in-law, the king had also created Duke of Lancaster. Counties palatine derived this designation of pallatio, because the owners thereof had in those counties jura regalia, as fully as the king had it in his palace, regalum potestatum in omnibus, as Bracton expresses it. They might pardon treasons, murders, and felonies, They appointed all judges and justices of the peace. All writs and indictments ran in their names, as in other counties in the king's, and all offences were said to be done against their peace, and not, as in other places, contra pacem domini regis. And, indeed, by the ancient law, in all peculiar jurisdictions, offences were said to be done against his peace in whose court they were tried. In a court lite, contra pacem domini; in the court of a corporation, contra pacem haliovorum; in the sheriff's court or turn, contra pacem vice comitis. These palatine privileges, so similar to the regal independent jurisdictions usurped by the great barons on the continent during the weak and infant state of the first feudal kingdoms in Europe, were in all probability originally granted to the counties of Chester and Durham, because they bordered upon inimical countries, Wales and Scotland, in order that the inhabitants, having justice administered at home, might not be obliged to go out of the country and leave it open to the enemy's incursions, and that Seld. Tit. Honor, 2, 5, 8, 215, 7 im. 138. Asterisk Pat. 25 Edwa. Roman 3. P. 1 M. 18 San. L. 3C. 8 Section 4. Fords Gen. Hist. 112. 4 Ints. 204. Jetwison v. Dyson 9M. N.W. 540. Cart. 36 Edwa. Roman 3. N. 9. Ebertson Ch. V. I. 60. Pat. 51 Edwa. Roman 3. M. 33. Plowed. To the laws of England. 91. The owners, being encouraged by so large an authority, might be the more watchful in its defence. And upon this account also there were formerly 2 other counties Palatine, Pembrokeshire and Hexhamshire, the latter now united with Northumberland. But these were abolished by Parliament, the former in 27 Hen. Roman 8, the latter in 14 Eliz. And in 27 Hen. Roman 8 likewise, the powers before mentioned of owners of counties Palatine were abridged, the reason for their continuance in a manner ceasing. Though all writs were still witnessed in their names, and all forfeitures for treason by the common law applied to them. Of these 3, the county of Durham remained longest in the hands of a subject, asterisk, as it belonged to the Bishop of Durham for the time being, till vested in the crown by the statute 6 and 7 will. Roman 4. C. Y. Whereby this franchise and all its forfeitures and jura regalia were transferred to the then king, his heirs and successors. The earldom of Chester, as Camden testifies, was united to the crown by Henry Roman III and has ever since * been one of the titles borne by the eldest son of the sovereign. But as the jurisdiction of the courts of Westminster has been extended to this franchise, and the jurisdiction of its own courts at the same time abolished, justice is now administered therein as in any other county of England. The county Palatine, or Duchy, of Lancaster, was the property of Henry Bolingbroke, the son of John of Gaunt, at the time when he wrested the crown from King Richard Roman II and assumed the title of King Henry Roman IV. But he was too prudent to suffer this to be united to the Crown, lest, if he lost one, he should lose the other also. For, as Plowden and Sir Edward Coke observe, he knew he had the Duchy of Lancaster by sure and indefeasible title, but that his title to the crown was not so assured, for that after the decease of Richard Roman II, the right of the crown was in the heir of Lionel Duke of Clarence, second son of Edward Roman III, John of Gaunt, father to this Henry Roman IV, being but the 4th son. And therefore he procured an Act of Parliament, in the 1st year of his reign, ordaining that the Duchy of Lancaster, and all other his hereditary estates with all their royalties and franchises should remain 10 gu, RV, and 1 will. Roman 4, c. 70. Plowed. Rep. 215. 4 inst. 92 of the country subject to him and his heirs for ever, and should remain, descend, be administered, and governed in like manner as if he never had attained the regal dignity. And thus they descended to his son and grandson, Henry V. and Henry YI, many new territories and privileges being annexed to the duchy by the former, Henry VI. being attainted in 1 Edwa. Roman 4 this duchy was declared in Parliament to have become forfeited to the Crown, and at the same time an act was made to incorporate the Duchy of Lancaster, to continue the County Palatine, which might otherwise have determined by the attainder, and to make the same parcel of the duchy. And farther, to vest the whole in King Edward Roman IV, and his heirs, Kings of England, forever, but under a separate guiding and governance from the other inheritances of the Crown. And in 1 Hen, Roman 7, another act was made, to resume such part of the duchy's lands as had been dismembered from it in the reign of Edward Roman IV, and to vest the inheritance of the whole in the king and his heirs for ever as amply and largely, and in like manner, form and condition, separate from the crown of England and possession of the same, as the 3 Henrys and Edward Roman IV, or any of them, had and held the same. The Isle of Ely was not a County Palatine, though sometimes erroneously called so, but only a royal franchise. The bishop having by grant of King Henry VIII, jura regalia within the Isle of Ely, whereby he formerly exercised a jurisdiction over all causes as well criminal as civil. A franchise now also vested in the Crown. There are also counties corporate, which are certain cities and towns, some with more, some with less territory annexed to them, to which out of special grace and favour the kings of England have granted the privilege to be counties of themselves and not to be comprised in any other county, but to be governed by their own sheriffs and other magistrates, so that no officers of the county at large have any power to intermeddle therein. Such are London, York, Bristol, Norwich, Coventry, and many others. For certain purposes connected with the administration of justice, England and Wales have also been divided into districts, some of which comprise several counties or parts of counties, while others consist of a part of a county only. Thus for the proof of wills and the grant of letters of administration, local J. Perry. 2 Hen. V. N. 30, 3 Hen. V. 6 and 7 Wall. Roman 4. C. 87 and 7 Will. Roman 4. N. 15. And 1 Vict. C. 83. To the Laws of England. 93 registries have been established, with districts attached to them, approximating more or less to the limits of the ecclesiastical courts, whose jurisdiction in these matters has been transferred to the Crown. So for the trial of offences within the jurisdiction of the justices of the peace, counties have, as we shall see afterwards, been formed into divisions for holding petty and quarter sessions. And in like manner the county courts have each of them an exclusive jurisdiction within a certain district. The limits of these different districts have in some cases been fixed by statute, and in others assigned by order in council, but they exist and are recognized only for the particular purpose for which they are created. And thus much of the country is subject to the laws of England.
This has been a production by the Mental Chemist, for study and education. Copyright 2024.